matter. Item number 1.
Please, your lordship. My lord, the petitioner is a scheduled tribe person, my lord. Challenge the order in annexure 4 at 26,394, mainly on the ground that the learned ADM has no jurisdiction to.
So what is the writ petition number?
Written up 329 of.
No, so we are in the, which list are we now?
Weekly.
Oh. One minute. Yes, sir, please carry on.
My lord. The petitioner is an scheduled tribe person of district of Kandhamar, Fulbani. Well, he was granted a lease of 2 acres of land for agriculture purpose on 18,175 in under the lease principles, approved lease principle. Subsequently, notice was issued to him under Section 7A3 of Odisha Government Land Settlement Act. He has shown cause that this the proceeding is not maintainable because the land has been settled on lease principle. So OGLS Act has no application to initiate this proceeding. But finally, the order was lease was set aside, and 19 persons are aggrieved in that against a similar order, my lord, identical order. And all the 19 persons have filed writ petition before your lordship. And 18 cases have been disposed of. And this is the last case. And the last, before this case, my lord, the OJC number 520 of 1995, it has connected record, the record has come.
Let's see it. OJC 520.
520.
What's the order in 520? So it has been set aside. All these matters have been
Yes,
set
my
aside.
lord.
No, what I beg to submit, the point which he wants to make out that once the lease is granted under the OGLS Act, it could not have been cancelled under the,
No,
on lease, under
you have
lease
to have
principles.
previous approval of the RDC.
RDC, yes.
Ah.
That order which your lordships have passed in 1995, that is relying upon an OLR decision. Your lordship may kindly give us half an hour time. I will get that book and that decision of
Chandrakala Padi.
Chandrakala Padi. We have to verify that whether.
Why, that is there. It's been quoted also, sir. It's been quoted. The judgment also has been quoted.
Supreme Courts.
You see, this writ petition questions an order dated 26th March 1994, passed by Additional District Magistrate Fulbani in RC number 5/86-87 under Section 7, capital A bracket 3 of the OGLS Act, cancelling the lease granted in favor of the present petitioner. Paragraph. Present petitioner bracket who belongs to a scheduled tribe. Bracket close. Counsel the petitioner at the outset points out that an identical batch of writ petitions has been already disposed of with this court. Full stop. In particular, he refers to the order dated 10th August 2017, passed by this court in OJC 520 of 1995, where in identical circumstances, the impugned order was quashed, primarily on the ground that it was without the previous approval of the Revenue Divisional Commissioner, bracket RTC. Paragraph. This court has called for the record of OJC 520 of 1995 and has perused the above order of this court. stop. Indeed, it is more or less on similar circumstances that the lease granted in the aforementioned case was cancelled, and by a similar order dated 26 March 1994. So this court has relied on the decision in Chandrakala Padi versus State of Orissa, 1997, 1 OLR 52, and on the ground that the proceedings were initiated without the previous approval of the RTC. The order has been set aside. Paragraph. The present case is identical to the aforementioned case, and therefore, on the same ground, namely that prior approval of the RTC is not obtained, the impugned order is hereby quashed. The writ petition is allowed, but no order is quashed.
Weekly list old matter item number 2.
In item number 2, Lordship will see the first matter which is appearing. Mr. Amitabh Das is the counsel for the petitioner.
Yes, ma'am.
And is Mr. Das there?
Yes,
Yeah,
he's
yes,
here.
So the first matter, the petitioner has died in the meantime, my lord.
Ah,
I can know. So that is also a OGLS matter, my lord. And he is the original lessee, my lord. He has sold the property, my lord, to the subsequent purchaser, the other writ applications where Mr. Rath is appearing, my lord.
so you're not pressing the first matter then?
No, so for first matter is concerned, my lord, no cause of action
Mr.
survives.
Das
So
states
far as-
that with the petition having died, no cause of action survives. The petition is accordingly disposed of. Yes, Mr. Ratha.
Lord, all these batch of matters, Lord, we are purchasers from the lessee.
Without notice to you, it has been cancelled.
Lord, cancelled, but there is a point which apparently may go against me.
Ah.
Lord, that is that they say that after cancellation we have purchased.
Order is passed in 87, they have purchased in 1988.
Oh.
After the cancellation, they have all purchased.
Okay.
So that by the time the sale deeds were obtained by the petitioners in all the other connected matters, the lease was already cancelled.
Oh.
And now the lessee is not pressing the writ petition by which the impugned order is the cancellation of lease. So that order is confirmed.
Ah.
If that order is confirmed, a purchaser who purchased the land after cancellation of the lease, he has no right.
No right to stop. Yeah. All right.
The cancellation was also after 14 years.
But whatever.
That you have not pressed it. No?
You say this writ petition 12272 and others. These are writ petitions by purchasers of the land from the original lessee whose lease stood cancelled by an order dated
My lord, 21st September 1987.
21st September 1987 of the Additional District Magistrate
By the
Bhubaneswar
ADM
in RC
Bhubaneswar.
case number 622 of 1987. The challenge to that order by the original lessee in OJC 8942 of 1985 has been negatived by an order passed today by this court in the disposing of the above writ petition of the original lessee on the ground that with the original lessee having died, no cause of action survives. Stop. In effect, therefore, the order dated 21st September 1987 of the ADM Bhubaneswar cancelling the lease has attained finality. Paragraph. As far as these writ petitions are concerned, all of these petitioners are purchasers of different parcels of the leasehold land after the lease has been cancelled. Stop. Despite the fact that they may have been purchased under registered sale deeds, fact remains that on the date of the purchase, there was no title in the original lessee to convey to the purchaser. Full stop. In other words, on the date of the purchase, the land already stood vested in the government. Full stop. Consequently, none of the sale transactions that took place subsequent to 21st September 1987 have any legs, have any validity. Full stop. On the above short ground, none of these writ petitions has any merit and is accordingly dismissed, but no orders is to cause.
Weekly list item number 3.
Item number 3, Your Lordship, I have filed an application for intervenor, my lord.
Yes.
I filed an application, Your Lordship.
Let's see who's for the petition.
I am for the petition.
Ah.
Lordship, I'll take your Lordship's, with your Lordship's permission, at page 26, your Lordship.
Yes.
Certain fact, all the three courts found that it's a OEA matter, so Orissa Estate Abolition Act,
Right.
your Lordship, wherein the ex-intermediate, the contest is between one of the Rayat, who says who is in position on the date of vesting, and the vendor, and the daughter-in-law is the vendor of the opposite part, number one. So the father-in-law is supposed to be the ex-intermediary. He was found, as per record, as per page 26, he was found to be 80 acres of land in possession, your Lordship. That has not been decided by any of the courts, your Lordship, whether he is in excess surplus or not. OLR case is pending, as well as in OEA, 33 acres has to be is the limit, your Lordship.
Limit.
That has not been, if Lordship may kindly appreciate, if he was found to be surplus, as per section 40 of the OLR Act, she could not have sold it is a bar that she cannot sell. If that goes, their claim and all the orders goes, your Lordship. So OLR case, as per page 26 in the by the Tehsildar, is pending. In the appellate as well as the revisional court, no one has decided about that. No one has taken into consideration, not even a single line, your Lordship. I have raised it in the appeal, but it was not decided. My humble submission at this point would be, your Lordship, if the OLR is not found surplus, I don't have a case. If it is found surplus, then she could not have sold to the present opposite parties, and I would be a better right with the state, your Lordship. Because I was found the second to be second in line after the ex-intermediary, not the purchaser of the surplus land.
Just give us a few dates.
Your Lordship, page 26, if your Lordship says.
Yes.
Page 26, repetition.
That's the Tehsildar's order, Annexure 3. This is the second round of litigation. They had come in 1982. This honorable court has directed for issuance for fresh consideration. In this fresh consideration, Annexure 3 is the fresh consideration, wherein it says OLR case number 22 of 74 was instituted under section 42 and was finally dropped in 1976. But however, it was again reopened and it is still pending on the date of order of the Tehsildar. In appellate as well as revisional court, no mention about this.
But just read this whole thing.
Pardon me, Your Lordship.
Just read this entire paragraph.
Yes, Your Lordship. OLR case number 22 of 74 was instituted under section 42 of OLR on 5/4/74. The case of the was finally dropped on 30/11/76 on the ground that the landholder, namely Ananda Behera Ratna, Brundan Sau and Subesha Sau, Dandapani, Prafulla Kumar Sau and Purusottam Behera Ratna have bought the lands partitioned by deed dated 700/4/4/64. The share of each of the land of the within the ceiling limit. The case was dropped. However, the case has been reopened after a review of the OSD LR Chhatrapur. The case is under inquiry. Any land found to be in excess in ceiling at all shall be vested to the state, free from encumbrances as per provisions of law. Hence, the proceeding of the OLR Act may not vitiate the present proceeding under the law. How come this finding, Your Lordship? May not vitiate.
Because if it already vests in the state, there'll be nothing to do under the OEA Act.
Obliged. And if your Lordship sees, again in the appellate court, page 33, I have raised this issue, but it was not dealt.
Yes, Mr. Manti?
This issue was raised before the appellate court and
Not dealt with, he says.
my lord,
Not dealt with.
not dealt with. And also it is now revisional court also passed the order that is at page
Again, without dealing this issue.
Annexure 5.
Yeah. Again, without dealing with the issue.
ADM has passed the order. Lordship may direct to deal with this issue. by
So
the-
remanded back to the Tehsildar?
No, that if your Lordship can remand it to
The
ADM.
OEA collector, sorry. OEA collector Khali Court.
But ADM is the revisional of all these orders culminated with the revisional
Yes.
order.
So it goes back to the revision court.
May I suggest you also, because it was there in the appeal court, and appeal is a fact-finding court also, because revisional power is very limited. If it goes to the appellate court where it was raised and not dealt with, that should, with my humble submission, that should be the
It's
appropriate
okay.
forum to decide.
It's
What happens to the intervener? They await the outcome in the sub-collector. We can allow the interveners to be also heard.
Yes,
by the
they will
sub-collector.
appear before the
They will be
sub-collector.
heard.
All right.
Lords, I have filed an application under order on Rule 10, Lords. That Lords, my successor was a party in the OA proceeding, but Lords, after his death, Lords, he has not been made as a party, Lords. Therefore, I have filed an application that I may be imputed. I am selling on the same board with the petitioners, Lords.
All right.
All
What is your
possible
IA number?
stakeholders, all possible stakeholders will appear before the sub-appellate authority.
No, what is your IA number?
IA number, my Lords, 136 of 2019.
And madam, yours?
IA number 22 of 2021, Your Lordship.
I see. All right. The challenge is this.
My lord, I may be pardoned. My lord, one thing I want to draw your lordship's
Who
kind
are you,
attention.
sir?
I am for the opposite part number 1 and 2.
The purchaser.
The purchase.
Ah.
My lord, your lordship may kindly peruse page 24. Previously, the petitioner moved before this honorable court, and this was the finding. Your lordship may kindly peruse. The honorable high court, in their order dated page 24, annexure 3, internal page 10.
Yes.
The Honorable High Court, in their order dated 17/4/89, has held that the OEA collector shall dispose of the OEA case number instituted on the H application filed by Anand Behra Ratan under section 6 and 7 of the OEA Act in accordance with the law. The Honorable High Court further observed that depending on the result of the aforesaid mentioned proceeding, the proceeding initiated for settlement of the case land with the read
So this is
petitioners
exactly
will
what
be
he's
taken.
arguing.
My lord,
What he's arguing, he says without
My lord.
the outcome of the OLR.
only one aspect. This honorable court previously observed that this matter will be decided only one aspect. Only the application filed under section 6 and 7 of the OEA Act.
But that's what he's arguing also.
7 has not been considered.
Yes.
7 has not been considered. 7 says
But three
in
courts.
excess of 33 acres.
My lord and friend lost in the 3 courts, my lord.
That I have already
But none of the courts has considered the OLR angle. This is the second round of litigation concerning land admeasuring land in village Kamaladeipur, Kalikot Tehsil, Ganjam district. Arising under the Orissa Estate Abolition Act, bracket OE Act. In the first round,
Appeal order against it.
against the appellate court's order where it was remanded.
yes, yes,
I had come in appeal.
yes, yes.
I have come in.
All right, sir. All right. Just listen to it.
Revision.
It is the order dated 7th March 1981 of the Appellate Court in OE Appeal number 11 of 1979 and 13 of 1980. Shri Maguni Nayak filed OGC number 7 1981 in this court. Full stop. By order dated 17th April 1989, this court directed that the OEA collector should dispose of OEA case number 699 of 1977, instituted on the H application filed by Anand Behra Ratna under section 6 and 7 of the OEA Act in accordance with law. The High Court further observed that depending on the result of the aforementioned proceedings, the proceedings initiated for settlement of the case land with the writ petitioners will be taken up. In other words, if the application under sections 6 and 7 of the OEA Act for settlement of the land with the intermediary or anyone claiming through him succeeded, then the question of settling the very same property in favor of the writ petitioners would not arise. If the aforementioned application was rejected, then the writ petitioner's claim would be considered in accordance with law. When the case went back to the OEA collector, Khali Court, the first impugned order dated 18th March 1992 was passed. Settling the lands in favor of Ramesh Chandra Panda, Durmila Kumari Panda. They are opposite parties 1 and 2.
Yes.
Yes.
Opposite parties 1 and 2. That it comes from the petitioner points out that even at the stage of the appeal filed against the said order, the petitioner had raised the issue of determination of excess lands in terms of the Orissa Land Reforms Act, which is the year
1960. 1960.
1960, bracket OLR Act. This was in fact noted in the which page is that?
26, Your Lordship. Internal page 26. Under Annexure 3.
Yeah. In the order of the
OEA collector.
OEA collector. Where by observing as under, take from page 26 the second paragraph.
Page 40. Your Lordship. Running page 40.
Yeah. Internal page 26 and page 40. However, despite noticing the above issue, the OEA collector did not, in the final analysis, account for this development and proceeded to pass an order settling the lands as indicated here in the form. Paragraph. Counsel petitioner points out that the above point was raised both before the first appellate forum, that is the sub-collector Chatrapo, and thereafter before the ADM Ganjam, but not dealt with. Paragraph. Indeed, if under the Euler Act certain lands are found to be in excess and already vested in the state, then a different set of outcomes would arise. First off, It is imperative, therefore, for the authorities exercising powers under the OEA Act to await the outcome of the proceedings under the OLR Act. Paragraph. On the above short ground, the impugned order dated 11th March 1997 of the ADM Gajam and the corresponding order dated 28th April 1993 of the Sub-Collector Chhatrapur are hereby set aside. And the matter is remanded to the and the appeal before the Sub-Collector, being OEAA number 5 of 1992 by the present petitioners, is revived. To stop, the said OEA number 5 of 1992 will now be listed before the Sub-Collector Chhatrapur for directions on 4th April 2022. Full stop. The interveners who have filed Miss Case number 7092 of 1997 and IA number 22 of 2001 are permitted to appear before the Sub-Collector. And make
Mine IA is 136 of 2019.
yeah, IA 136 of 2019 and IA 22 of 2021 are permitted to appear before the Sub-Collector on the aforementioned date and make their submissions. Till then, the status quo as of today shall be maintained. The writ petitions disposed of the above.
Weekly list item number 4.
May I please, Your Lordship? Item number 4, Your Lordship. This is under Annexure 4. I am challenging Annexure 4. The facts, if Your Lordship permits me to clarify, Annexure 1 was passed under Section 41 of the Hindu Religious Endowment Act, wherein ex parte it was awarded in favor of opposite part number 1, saying that the DT's sole hereditary trustee is opposite part number 1. On that basis, Annexure 4, page 24, if Your Lordship sees, was passed that as because of that, there was some income of the DT, land acquisition was made and around 18 to 20 lakhs was deposited, and it is a question of interest from that account, Your Lordship. So page 26, Annexure 4, it says that it has to be because he is the sole hereditor, she will get everything. During the pendency of this case, Your Lordship, I have Annexure 5 to an additional affidavit wherein it was stated that the 82 order is not binding upon me, and all opposite part number 1 to 3 as well as the petitioner number 1 to 3 and opposite parties all will get share, equal share. That is Annexure 5 during pendency of this writ petition. Now, my humble submission, Your Lordship, is on the base, if that 82 order is not binding upon me and a fresh order has come, then let the authorities take a fresh view, keeping in mind Annexure 5. These are the developments during pendency of this writ application.
Which page is Annexure 5?
I have filed an additional affidavit in 2001, Your Lordship. Sorry, 25/3/2006. That is
additional rejoinder. Is it an additional rejoinder affidavit?
not a rejoinder, Your Lordship, additional affidavit at flag T, Your Lordship. Flag T. Additional affidavit of the petitioner at flag T.
Is this dated 25th March 2006?
March 2006.
25th March.
Yes.
Yes.
If your lordship sees the order at Annexure 5 dated 12th June 2001, at page 18 of that affidavit, your lordship.
It's actually unreadable. This 12th June, no? Totally unreadable.
Pardon me, your lordship.
No, it's unreadable, I'm saying.
Page 19, if your lordship. I have quoted it as well in my affidavit. I've quoted the same in the affidavit also. The findings. Page 19, it says the last part, if your lordship permits me, the operating part. Hence, the order passed by the then learned additional assistant commissioner of endowments Berhampur, wide order dated 8/9/2002, is not binding on the petitioners and opposite partner 2 and 3. Hence, this issue is answered accordingly. That the first observation is that it was not binding upon me. Second, subsequent pages, it has been said at page 22, it has been said it has to be equally divided amongst all the co-trustees. So 82 is not binding upon me. Order of 82 is not binding upon which Annexure 4 was passed, wherein only opposite part number 1 was to be given all the share. So my humble submission, after 2001 order, if the if Annexure 4 will be revisited, it will end the litigation. The commissioner endowment, if he is directed to on that basis, if he sees.
This order of 12 June 2001 is by who?
Is one by me. I filed. I was the petitioner.
No. It's by the additional assistant commissioner.
Yes, your lordship.
I'm appearing for OP1. That order is no more in existence. Let him finish, I will say. That order is no more in existence. In appeal, it has been dismissed and there was an observation in the appeal. No party will take, and the lordship may see the page 23. That case was dismissed. Additional affidavit. First 41 was decided, case was ultimately dismissed, and in appeal, the appeal was withdrawn. I have filed I will show you from your lordship. With an observation, no party will take a decision, advantage of that order. I will come to that, let him finish. That is no more in existence.
There are several prayers in that petition, your lordship. These observations were in my favor, and certain observation that what relief I am entitled, that was dismissed. So not in entirety, your lordship.
But I am
the 5 issues.
Number 2, if your lordship permit me, OP number 2, my lord.
Yes.
But if your lordship looks at the prayer in the writ application,
yes.
Till disposal of the 41 proceeding, that is already over.
Oh, so the prayer has been rendered infructuous then?
Yes.
That prayer is rendered infructuous.
41 is over and appeal is also over. That is in my death chart. Appeal was
withdrawn, your lordship.
Thus, he has also filed a suit, title suit.
That I am not.
So you actually you follow up on that then?
Your lordship.
I am not aware of that. If my learned senior says,
no, it is there. Annexure C/1. It is there, my lord. If your lordship, title suit 64 of 97 is already on record.
It appears that your prayers in the present petition have been rendered infructuous. Additionally, Mr. S.P. Mistral and the senior counsel appearing for opposite party number 2 draws attention to a summons issued in a civil suit filed by the present petitioners, that is TS number 64 of 1997, in the Court of the Civil Judge Senior Division, Berhampur, which is stated to be pending. In that view of the matter, it will be open to the petitioner to pursue the remedies in the aforementioned suit in accordance with law. No further directions are called for as far as the present petition is concerned. It is disposed of.
Lordship, my record, I have appeared for OP number 1.
There was an interim arrangement by this honorable court.
The suit will take care of.
Suit will take care.
That may be observed here.
As far as the interim arrangement is concerned, it will be open to the petitioner to seek appropriate remedy, interim reliefs in the pending suit in accordance with law.
Actually, one revision is pending before the Commission of Endowments, challenging the same order which has been stayed during the because of pendency of this case. That revision is also pending. I am giving the number. That revision number.
May I clarify one thing actually?
Here,
9 of 2001 of 9.
Revision case number 9
of 2001.
I cannot say, my lord.
Yes, that is there.
In accordance with law before the
Commissioner of Endowments.
Commissioner of Endowments.
Mine. That is pending. Obliged.
Grateful.
Weekly list item number 5.
For the petitioner in this region.
My lord, from the beginning, I would like to submit that the file is not available with me. Either your lordship may pass it over, I will get the file from the court file, and or he may say what from his submission if I can defend my case.
Or you can take a file from us.
Kindly only file, yes.
Annexures 5, 6, 7, 13, and 14. Yes, sir. Please carry on.
Okay, start.
The property involved in this case is a khasmal property. The nature of khasmal property is different, completely different, so far other lands of the government. The lessee in this case, in not only this case, in all the cases, so far khasmal property is concerned, he has got a right, heritable right, transferable right, and inherent right of renewal. It is just like a private land. Now I am giving, because there are different proceedings for which I have prepared a debt cert. I am giving the debt cert. And a decision which covers earlier decisions of this court regarding khasmal.
Kindly give him a copy, sir.
Yes.
Copy.
Yes, please.
Ahmad, son of Nur Muhammad, was the lessee of 72 decimals prior to 4/11/20. Then 4/11/20, Ahmad transferred the land to one Purostam Jina. Then 20th May 1946, Purostam Jina transferred the property to Shishir Kumar Das. Shishir Kumar Das is the father of the petitioner number 1. Then 1860, Shishir Kumar Das had applied for khasmal lease by khasmal lease case number such and such for an area of 72 decimals. The case record was signed by the Tahsildar Chanbali up to 9/12/67, on which date the Tahsildar submitted proposal for lease of 72 decimals in favor of Shishir Kumar Das. But the order of the collector is not available in the case record. That is para 7 in the counter of the state. Then 27/1/79, Shishir Kumar Das filed petition for renewal of khasmal lease for a period of 70 to 80, and such renewal was allowed by the collector. So lease was renewed till 1980. Then 1580, lease was executed in favor of Shishir Kumar Das for 10 years, from 60 to 70 and 70 to 80. That is annexure 2. In 81, Shishir Kumar Das applied for renewal of lease by khasmal lease case number 4 of 81. This is important matter. Then 90, petition number 2 filed khasmal transfer case number 16 of 90. In between that from 25/11/88, and after that Shishir Kumar Das transferred some lands to other opposite parties. So the petition number 2, in whose favor the property was transferred, he filed khasmal transfer case number
16 of 90. Then petition number 3 and 6 also filed Khasmar case number 70 of 90. In the counter, the state government has stated that on bar 12/5/90, Taldar dropped the Khasmar renewal lease case number 4 of 80, which was filed by Shishir Kumar Das, on the ground of his signatures in English on the application and for his non-appearance. This is wrong, my lord. This is passed. This order is passed in Annexure 5. 12/5/98, not 90. 12/5/98 I have stated. This order is filed. And because they have stated in the counter, that's why I have mentioned it. Then one thing in between that, after that, Act 1 of 91, Government Land Settlement Act was amended and Khasmal property was included in the Government Land Settlement Act in 91. 92, Taldar initiated OPLE proceeding under the OPLE Act for 10 days. Then 93, a suit was filed which was withdrawn the liberty to move in appropriate form. Then 12/5/98, Khasmal transfer case number 80 was 16 and 17 of 90 are dropped. Then 12/5/98, Taldar dropped the Khasmal lease case on the ground that Shishir Kumar Das, who is he applied, in his application he has put his signature in Bengali and later on he signed in English, for which it was dropped. And in the major, they have said that in the major settlement, the property was recorded by the settlement authorities in the Abada Jogya Anavadi Khata. So they initiated the OPLE proceedings. And all that happened in 1998. Although Shishir Kumar Das applied much earlier, 16 years before that order. After 16 years of the application, his application was rejected and OPLE proceedings were initiated. So my submission is that once Khasmal property is transferable, heritable, and just like private land, and he applied for renewal in 81, 91, the Amendment Act came into force where it has been stated in the amendment that the property in which a person is staying for 5 years, the land will be recorded in his name. This is the position 91. And after 91, they initiated the encroachment proceedings.
Yes.
All right.
What is the reason 91? Because one Runi Ram Agrawala, the adjacent owner, has encroached my land. I have filed a suit. And the Tahsildar immediately took action and dropped all the proceedings, initiated encroachment cases to give favor to Runi Ram Agrawala.
May I please, Your Lordship, the prayer portion of the writ petition, the prayer is to quash basically the orders of the Tahsildar under Annexure 13 and 14.
Correct.
I will take Your Lordship to page 57, Annexure 13. This is put up to me today. The petitioner is absent in spite of repeated calls. Page 57 of your writ petition. Once Ruri Ram Agarwal filed objection stating that the suit land is a disputed one for which title number so is continuing before the Honorable Court Civil Judge Senior Division Bhadrak. Further, he has settled that Hal plot number so has been recorded under Government Katha. One civil division bearing number so is pending before the Honorable High Court Orissa. Therefore, the prayer for rejection of the case. As per geo number so, the petitioner is neither a lessee nor a sublessee or subsequent sublessee. The so-called original lease, Sri Shishir Kumar Das, lessee Shishir Kumar Das, is not present to produce any evidence. Khasmal lease case number 4 of 81 of Sri Shishir Kumar Das was tried before this court since 22/1981, but till date, Shishir Das has not approached before this court, appeared before this court. Hence, the case number so and so 4/81 has been dropped. In view of the facts cited above, I am constrained to believe that there is no such person like Sisir Kumar Das, who is lawful leaseholder and who has subleased the land to the present petitioner. Further, this is a fact finding that there is no Sisir Kumar Das who is the lawful lessee and he has.
It's a surmise. It's not a finding so much. Just read that sentence
The
again.
next order, your lordship may kindly see the next order, that is Annexure 14 sought to be quashed. 30th June 1998. Peruse the letter of so-and-so Revenue Inspector Chandbali, which forms a part of case record. It reveals that one Jalaso in Mauja Chandbali bearing plot number 294 under Khata number 129 Rakhit, measuring an area 16 decimal is existing, which required public auction for interest of the government. He has also reported to put the said Jalaso in public auction every year, and the cost of the source would be rupees 60. RS Chandabali requested to set up offset price of the newly directed source may be 60 only. Hence, as per report of RI Chandbali, the source is treated as a Swaraj source from the current year 1998-99. The offset price of the source is fixed at rupees 1. So direct RI Chandbali to conduct auction sale. Peruse the bid sheet and proclamation of notice by RI in charge Chandbali by his letter number so, which forms a part of case record. It reveals that RI in charge conducted the auction sale of the source from tank in Mauja Chandbali in plot number so, measuring an the sale has been knocked down in favor of the highest bidder, Bhuvana Das, son of Bhamar Das. The full bid amount has been realized by RI by so, and the issue L form is concerned RI for necessary entries at his level. So what I beg to submit, it is already converted to a source and it has already been leased out to third party, and the auction has already been conducted and bid has already been knocked in favor of a party who is not a opposite party in this case. So it is in government khata.
What is the interim order here, sir? There's no interim order.
That's why one content petition is filed.
No, there's no interim order, sir. How will you file contempt?
Interim order is passed on.
What is the interim order?
9/11/98.
Interim order is that.
But with this kind of an interim order, how do you sell it off an auction?
No. Petitioner shall not be evicted from the disputed property if not already evicted.
So they were already evicted?
Yes, that is the case. That is his case. But the contempt is a different thing. Your lordship may call
under the Enforcement Act, there are procedures.
No.
How to evict?
1 minute, sir. Are you in possession?
Yes. I'm in possession.
How can it be, sir?
1998 to today, 2022. It is already 24 years back. We are auctioning. This is a tank. And
No. What is the position before it happened before 9/11/98? The alienation.
And that, if your lordship say, I can get instruction.
No. Unless we know the ground situation, sir, he'll claim that he's still in possession. What is your information? Is the question.
Then your lordship may fix it to next week. I'll get the ground status of this land.
Sir, you would know.
What the impugned order reveals that the government has already taken over possession, auctioned the land to third party. And
No. I'll tell you why. If despite the auction, he's still in possession, you have not given the auction purchaser possession of the land, it will fetch much more if you have went for a fresh auction.
During 1998, it was 60 rupees. Must have been raised.
Yeah, much higher now.
Must have been. It cannot be on section rupees only 60 rupees. It is impossible.
Yeah. No, then what happens is the question.
And another thing I want to raise before you.
The
impugned order is passed by the Tahsildar under the OLR Act. OPL Act. He can file appeal against that order before the sub-collector. Sub-collector will take care of all these things.
Those are without jurisdiction.
No. Without jurisdiction, that point can also be raised before the appellate authority. Only by saying that it is without jurisdiction, that is why I have invoked 226. That will not suffice. That is my responsible submission. He can raise this
all
point.
that depending on what the ground situation is.
That because what I find, so field ground status is to be.
No, why did you file a contempt? Let's understand that, sir.
Pardon.
Why did you file a contempt?
First of it.
Why did you file a contempt, sir? Contempt petition. Why did you file?
Yes, my lord. Your lordship would see the order number 3. petitioner shall not be evicted. Your lordship will see the contempt file.
I think contempt is not tagged with this case.
Yes, yes, that is
Only
in the list. Nine 11/98. Your lordship has passed the order. Your lordship will see the order.
So OCRMC 528. This is the contempt.
Yes, 520. Nine 11/98, the order was passed. In 8/9/99, they issued the notice for auction of the pond, which is 16 decimals out of 72 decimals.
What has that to do with the contempt, sir? Why did you file a contempt?
Contempt because on 9/11/98, this Honorable Court has directed not to evict the petitioner.
Correct.
And they put a portion of the property, some small portion of the property in 98 after the order.
I'm not able to follow. They up to auction one portion of the property.
Yes, yes, like one portion of the
No, but which was under your occupation.
This was my
No, but as a result, did they try to evict you as a result, sir? The main question is, was there any proceedings to evict you?
No.
Yes, you say
Only
that.
encroachment cases
Then where is the question for contempt, sir? Let us understand the contempt petition should have been that somebody is trying to evict me, therefore it is in violation of the order.
Any order your lordship can pass in contempt.
Sir, what is this? You do not know the factual position and then you are saying this, sir. Somebody should find out what is the position on the ground. Who are your clients? What is the age of your client? What is the age of your client?
Different ages. Alok Kumar Das at the time of filing was 57 years.
So now what will his age be? Almost 80?
Then
No, 1 minute, sir. Let's try and understand.
Yes.
98 means 22
years.
24 years plus
24.
81. He must be 81 now, Alok Kumar Das.
He must be
81.
81.
Then
Santilata Sahu, 52.
Even Srikanta Sahu will
Srikant
be
Sahu is
83.
82,
83.
Muktikanta Sahu, one thing I will point out. Muktikanta Sahu was dead and the substitution is filed, that is pending.
No, the others.
Other is 31 years.
Are they all still in possession, sir?
Yes, I am.
No, they're in joint possession.
In joint possession.
How big is this property?
Yes, Alok Kumar Das was the lessee's son. So for other persons.
How big is this property?
Area is 72 decimals.
Is it a residential house?
Yes, a residential house there.
There is a pond.
Pond is only within 11 or 16 decimals. You have said that 16
This is in Chandbali in Badrak.
Yes, Chandbali.
Kas Mahal lands. Can we not pass it over? You can find out.
I can ask the Tahsildar right now, but it is also a year-old case, so they have to find out that which case record and where they have to.
What is the result with regard to the OPLE proceedings?
Yes, that OPLE proceeding was
The
initiated.
proceedings which were initiated against
Yes,
the
my lord.
petitioners, what is the outcome?
That I have to.
Because even now, in 98, what drove him to file a contempt was encroachment case. 2 encroachment cases have been initiated under petitions 2 and 3. Earlier, an OPLE case was initiated under petition number 2.
Which is mentioned in the counter affidavit.
So do we restore those encroachment cases or the original caste case? The caste transfer case, caste lease case is rejected.
If your lordship
Tahsildar rejected the caste lease case filed by petition number 2. This become final. This is what a challenge here, is it? 5, 6, 7, 13 and 14.
if your lordship will direct me, within 10 days, I can file an affidavit of the Tahsildar mentioning all these facts. What is the ground reality? What is the status of the OPLE case? Whether he is in possession and whether the entire property covered by tank or homestead. Everything I will.
He has challenged. Annexure 7. Yes. Petitioner is neither. Come to that annexure 7, sir.
7.
Internal page 38. This is the order and the challenge. The petitioner is absent on call. Petitioner is neither a lessee nor a sublessee. Petitioner has submitted his plaint.
Annexure 7.
We can revive this case at the highest.
Therefore, the successors in interest would not have entered. Therefore, depends on the.
So what we can do is we can restore this Khas Mahal transfer case number 17 of 1990 before the Tahsildar. Let him have a full-fledged inquiry. You see, with the long passage of time, it is not clear what the ground reality is as far as possession of the lands in question is concerned. The court finds that one of the orders under challenge before this court in this petition is an order dated 12th May 1998, passed by the Tahsildar Chandbali in Khas Mahal transfer case number 17 of 1990, which had been filed by Muktikanta Sahu, son of Indramani Sahu. Asking that lands in plots 271 and 272 in Khata number 8 in Moza Chandbali should be settled in his favor by way of renewal of the term that was ending in 1990. An inquiry report had been called from the Revenue Inspector Chandbali, and even public objections were invited by an order dated 1/11/1990. However, on 12/5/1998, when the case was finally listed, Tahsildar dropped the case by passing the following order. Take from page 38. Consequent thereupon, encroachment cases were initiated against the present petitioners 2 and 3 by the Tahsildar. In the meanwhile, in the present petition on 9th November 1998, this court had directed that the petitioners would not be evicted from the property, disputed property, open quotation, if not already evicted, unquote. Subsequently, when a parcel of the land was sought to be put to auction, the petitioners filed a miss case number 5243 of 2000 on 8 June 2000, praying that the opposite parties, including the successful bidder, Sri Achyutananda Behera, and should be restrained from coming over to the disputed property, including the tank in question, till the disposal of the writ application. On this application on 11th April 2001, it is directed that possession of the petitioners shall not be disturbed by any person, including opposite party number 4, that is Achyutananda Behera, who had been impleaded separately by an order dated 30 June 2000 in MC number 5242 of 2000. Paragraph. That was the last effective order in the present petition. In other words, in over 2 decades now, there have been no effective orders in the present petition. Paragraph. With the petitioner's possession of the property in question standing protected by a series of interim orders, and that status quo continuing till date, the court considers it appropriate to pass the following orders. The impugned order dated 12th May 1998, passed by the Tahsildar Chandbali, is set aside, and Kasba Hill transfer case number 17 of 1990 is restored to the file of the Tahsildar Chandbali for being proceeded with in accordance with law. 2. In the said proceedings, the impleaded opposite party number 4, Sri Achyutananda Behera, will be heard after notice being issued to him in accordance with law. 3. Any other person who may have an interest in the property in question will also be heard by the Tahsildar. 4. The case will be listed before the Tahsildar for directions on 4th April 2022. A copy of the downloaded copy of this order will be produced before him by the petitioners. 4. The Tahsildar is requested to dispose of the said lease case after hearing the parties in accordance with law within a period of 6 months thereafter.
Another 5 has been set
Last,
aside.
till the disposal of the Kasma Hill, the above case by the Tahsildar, the status quo as of today shall be maintained.
Another 5 has been set aside. Another 5, which is the main order, that has been set aside.
Sir, we have dictated detail. I'm speaking into a mic. If you're not able to hear, I cannot help it, sir. Please. Huh?
One thing left.
Huh? Yeah, the contempt petition stands closed in view of the above order.
One thing, your lordship will pass an order in the substitution petition.
All
That is
right.
item number
The substitution application is allowed.
Okay.
All right. See, class case number 16 and 17 are restored. All right.
Weekly list item number 6.
orders. Same orders, my lord. Yesterday, your lordships have passed orders, interest on refunds.
Ah,
My lord, same orders may be passed.
what was just tell us again.
Lords, item number 14.
No, I know. The order, the final operative portion.
Lords, has not been, you have not received the order. We applied for certified copies. Not received.
No, we didn't dictate anything. We reserved orders and we dictated.
No, my lords, lordships are dictated orders.
Then you would know, dictated in your presence only. We'd reduce the interest to 6% or something, right?
6% interest of the 6% from the date of deposit.
Date of deposit. Correct. In view of the order passed yesterday in writ petition civil.
My lords,
if your lordship permit me.
You want to again argue?
No,
so that yesterday's order can be somehow referred to a larger bench.
Not again. Not again.
Lords, yesterday's orders with item number 14.
No, writ petition number, sir.
Your lordship, 3158 2004.
3158 of 2004. OJC number.
Your
WPC civil number 3851 of 2004.
3158.
3158 of 2004. The present petition is also disposed of in the same terms. Right. Petitions are disposed of. This entire lot. 4 petitions.
Weekly list item number 7.
So you have this one.
Weekly list item number 7. Weekly list item number 8.
Item 8, no instruction.
No instructions.
I'm appearing on the opposite part.
All right. All 3 matters.
Weekly list item number 9.
My lord, in this matter, instruction required. I send a letter to them, but it's a micro area, so.
It's all right. Then we'll simply say whenever you say counsel for the petitioner still is awaiting instructions. That view of the matter, the petition is disposed of with liberty to the petitioner to revive it in accordance with law in case any cause of action survives.
Weekly list item number 10.
May I please, Your Lordship?
Yes, please.
Here, the state has filed this writ petition challenging the order under the annexure 1 at page 8.
State Education Tribunal.
Yes, my lord.
My
lord, the background of the fact of the case involved in this case that the present opposite party initially the OP number 2 was appointed as a my lord Acharya and his service was terminated. So he preferred an appeal before the State Education Tribunal, and State Education Tribunal set aside the order of termination, and as such he was reinstated into the service, my lord. By the time the order State Education Tribunal passed the order, the managing committee appointed the present opposite party number 1. So, in order to implement the order passed by the State Education Tribunal in case of in the appeal filed by the present OP number 2, the opposite party number 1 was terminated, and the OP number 2 was reinstated by virtue of the order of the State Education Tribunal. And this fact was duly brought to the notice of the Honorable Tribunal that the order of termination has been passed as a matter of implementation of the order of the very same tribunal. And the Learned Tribunal has hold, your lordship will find that since the order of appointment of the present OP number 1 was not indicated that any subject to outcome of any court case or litigation, there was a non-compliance of section 10A, the order of termination was set aside. So now the question before your lordship, my lord, the post is 1, the person are 2. So pursuant to the order passed by the Learned State Education Tribunal,
who is appearing for the opposite parties? Have they been served, sir? 1 and 2. Just find out. Opposite parties 1 and 2 have they been served? Somebody appearing on their behalf last time. Does the stay?
Yes, my lord.
As a result, both are not working.
So OP number 1, sorry, OP number 2 is working. OP number 1 is not there. OP number
Who's
2
appearing for OP number 1? OP number 1 has not filed a reply. Or has he? Madan Mohankar is OP number 1.
OP number 1 has filed the counter, madam. Preliminary counter he filed on 12th March 2019. And rejoinder to that also has been filed.
They say in 24th March 2008, this court passed an order in OJC 1310 of 2000 asking the opposite parties to implement this very order that you've challenged.
Yes, yes, yes.
Is that right?
Yes, yes.
Then you've not challenged that order of this court.
That order has not been.
Then what happens, sir? Then this whole thing is infructuous.
Pardon me.
Then this whole petition is pointless. If in her petition filed by OP number 1 in 2000, an order has been passed in 2008 by this court saying that you have to implement this very order which has been challenged here, what remains in this petition?
No, that order OJC number 1310 of 2000 was passed in case of filed by the OP number 2.
You are admitting it, sir, in your rejoinder. Come to para 8 of your rejoinder, page 48.
My lord.
Oh, you're saying that because of a subsequent stay of granted of that order, the earlier order asking its implementation would not be given effect to. What happened to that writ petition? It's disposed of.
Yes, ma'am.
All right. The present writ petition challenges an order dated 21st August 1999 passed by the State Education Tribunal in appeal number 2 of 1999 filed by opposite party number 1. Stop. In the said appeal filed under section 10 capital A of the Orissa Education Act 1969, opposite party number 1 had challenged an order dated 18 November 1998, terminating the services of opposite party number 1 from the post of head Pandit of Pravakar Sanskrit Vidyalaya in Jajpur district. Full stop. Paragraph. The school in question is an aided educational institution within the meaning of section 3 bracket small b of the OE Act. Full stop. Initially, OP number 2 had been appointed as head pandit of the school. Full stop. Challenging the termination of his services, OP number 2 had filed appeal number 18 of 1996, which was allowed by the Education Tribunal by an order dated 27 March 1997, directing his reinstatement with all service benefits. Full stop. When this order of the tribunal was not implemented, OP number 2 filed OJC number 6641 of 1997 in this court, seeking compliance with the said order. On the other hand, the managing committee of the school filed OJC number 9883 of 1997 in this court, seeking the quashing of the order of the Education Tribunal. Paragraph. On 9th September 1998, OJC number 6641 of 1997 filed by OP number 2 was allowed, and a direction was issued to the present petitioners, that is the Department of School and Mass Education, to implement the judgment dated 27 March 1997 of the tribunal. Paragraph. In compliance with the order dated 9 September 1998, passed by this court, OP number 2 was allowed to resume duties in the school as head pandit. Paragraph. Since there's only one post of head pandit, there was a situation where both OP number 1 and OP number 2 could not have continued as such. Full stop. Consequently, the order dated 18 November 1998, terminating the services of OP number 1 had to be passed by the managing committee of the school. Paragraph. The ground on which appeal number 2 of 1999 filed by opposite party number 1 has been allowed by the Education Tribunal by the impugned order is that opposite party number 1 was not a party to the proceedings initiated by opposite party number 2. Full stop. Having been duly selected, his services could not have been terminated without prior approval of the authority under section 10 capital A bracket 1 of the OE Act. In the circumstances, the appeal is allowed and the order of termination of opposite party number 1 was set aside. Paragraph. There's one interesting development that took place even while a present writ petition was pending. Full stop. Opposite party number 1 appears to have filed OJC number writ petition number 1310 of 2000 seeking implementation of the order dated 21st August 1999 of the Education Tribunal. In the said writ petition, the said writ petition was disposed of by this court by an order dated 24th March 2008, directing the school to comply with the direction of the Education Tribunal within a period of 3 months. Full stop. Against non-compliance with of the said order, OP number 1 filed contempt case number 991 of 2009, which was disposed of on 5th February 2010, granting 4 months' time to comply with the order. Paragraph. In the meanwhile, the present petition came up for hearing before a division bench of this court, which on 18 March 2011 passed an interim order staying the order dated 21st August 1999 of the Education Tribunal. Full stop. As a result, there have been 2 conflicting orders. One passed by this court on 24th March 2008. The 24th March 2008 is a single judge order, right?
No, my lord, this is division.
Division bench order.
Yes.
Yeah, by a division bench directing the SNME department to implement the order dated 21st August 1999 and the subsequent interim order dated 18 March 2011, staying the operation of the order dated 21st August 1999 of the Education Tribunal. Stop. Clearly, in view of such conflicting orders, the SNME department could not be expected to implement the earlier order dated 24th March 2008. Paragraph. Today, despite service of notice, none appears, and a lawyer having entered appearance on his behalf, and despite his having filed a reply to the present petition, none appears for OP number 1. Full stop. In any event, he has not been able to get back on service despite the above orders, in view of the developments explained herein before. Full stop. Counsel for the petitioner informs the court that OP number 2 is continuing as head Pandit pursuant to the above orders. Paragraph. In view of the above status quo having continued for well over a decade, and with there being full justification for the SNME department not to have implemented the order dated 21st August, implemented the order dated 24th March 2008 in OJC number 1310 of 2000, the court considers it appropriate to set aside the order dated 21st August 1999 of the Education Tribunal. Full stop. In view of the earlier proceedings of this court and the orders passed in OJC number and orders passed by this court in OJC number 9883 OJC number 6641 of 1997. Wherein by the order dated 9th September 1998, this court had asked the judgment dated 27 March 1997 of the Education Tribunal in favor of opposite party number 2 to be implemented, the Education Tribunal could not have, ignoring the above facts, insisted upon OP number 1 being accommodated by the order dated 21st August 1999. Stop. Paragraph. Since the order dated 21st August 1999 of the Education Tribunal was set aside, clearly, the order passed by this court on 24th March 2008, asking for, in OJC number 1310 of 2000, asking for its implementation, is incapable of being implemented and is hereby rendered inoperative. Paragraph. The writ petition is allowed in the above terms, but in the circumstances with no order system.
Weekly list item 11.
Dear Lord, a revisional order under challenge in 38B of the OEA Act law. Essentially, it's an order of remand. Let me kindly have a glance at the last page of the impugn order. Running page 37. Some observations are creating problem that may be taken care of in view of the judgment of the Honorable Apex Court of 1962 Supreme Court. I'm just placing the last paragraph at page 37 of the brief.
Yes.
Paragraph number 8.1.
The moot point.
Moot point for this case is whether the tenant's ledger in respect of the Sutland, although Stitiban in origin and merged into sub-proprietorship latter, was prepared on the basis of a fraudulent via Ekpadya submitted to the revenue functionaries as sub-proprietor rights vest in the state along with the vesting of the state. This requires verification of the original Tehsil records and the via Ekpadya referred to by both the subordinate courts. Secondly, the existence and continuance of the school since 1953 require field probe along with the verification of documents since the vesting has taken place after 1953. The points specified in the preceding subparagraphs have to be thrust out by the OEA collector and after providing adequate opportunity to be heard to all the parties concerned, including the managing body of the school, the finding has to be arrived at. Now, the sole claim of the petitioner is that the very initiation of the proceeding under the OEA Act is not attractive because it is illegal, because the right of the petitioner is a Stitiban right, tenancy right, because the OEA Act is not applicable. Proceeding, the initiation of proceeding is illegal. That's why now it has been observed that some documents has been prepared on the basis of a fraudulent ekpadya that has not been produced by the petitioner. This observation may be taken, it may be demanded because the OEA collector has to decide it afresh, but without being influenced by the observations made that a fraudulent viand has been submitted now. And that is kind of I'm just producing the right from 1962 Supreme Court note. It is a five-judge bench decision. The OEA Act or the vesting doesn't affect the tenancy right. With that observation, the OEA collector may take care of that without being influenced by these observations, because this fraudulent, etc., which has been observed, that is completely absurd.
My lord, so far as the applicability of the OEA Act, what my learned friend is saying, that can be taken care of the learned Tahsildar and he can raise that point. Your lordship can direct that he will take care. But so far as these findings of the Board of Revenue is concerned, these things have to be examined by the Tahsildar. Otherwise, the truth will not be discovered.
He says he's also agreeing. He says, don't attribute the fraudulent thing only to me.
No, that is not the court has said that this is apparent and you examine it. Tahsildar is to examine. So if your lordship will say that Tahsildar will not be influenced by the Board of Revenue's order, then that part is excluded apparently. That is my only objective before your lordship, that should not be excluded from the purview of examination.
Yes.
Exactly.
All right. You say
as it appears, as if he has concluded that there is a fraudulent document. That may be taken care of. What my submission note is.
Because the fraud ground anywhere, any court can take cognizance.
All right. The challenge
Any proceeding is initiated that is being
the challenge the present petition is to an order dated 11th May 2003 passed by the Board of Revenue Orissa. OE revision case number 76 of 2002.
There are many cases.
Filed by opposite party number. Filed by the present petitioner, correct?
Present petitioner, he has in the meantime expired. A petition has been filed for substitution. That may be allowed.
The substitution application.
IN number 21283 of 2017.
Although the revision petition was disposed of by the Board of Revenue by remanding the matter to the sub-collector.
No, the
OE collector. Tahsildar,
the original code.
OE Tahsildar.
OE collector.
OE collector.
Yes.
Yeah, OE collector.
OE collector.
The petitioners agreed by the following observations in para 8.1 and 8.2, which read as under, reproduced from page 37, 8.1, 38, 8.2. Paragraph. Mr. Monti, learned counsel opinion, the petitioner states that while the petitioners have no objection to the OE collector examining the entire matter, he should not proceed on the basis that the Vian/Ekapadia found to be fraudulent by the member Board of Revenue is examined on the basis that it was the present petitioner who perpetuated such fraud. Full stop. According to him, the collector should examine the entire issue.
My lord may say OE collector.
OE collector should examine the entire issue without any preconceived notion of who may have been responsible for submission of a fraudulent Vian/Ekapadia. Paragraph. It is clarified that having heard learned counsel of the parties, the court clarifies that the OE collector, it will be open to the OE collector to examine the entire issue, including all documents, without any predetermination as to who may be the person producing the documents, which may be found to be fraudulent. Full stop. That has to emerge as a part of the inquiry to be conducted by the collector, the OE collector. Full stop. With the above clarification, the impugned order of the Board of Revenue is not interfered with, and the writ petition is disposed of.
My lord, status quo as on date may be continuing because one school is running on.
Till the disposal of the case by the OE collector, status quo as of today will continue. The LCRs be returned forthwith by the court. So both petitions are the same.
There are two petitions filed by my lord and friend. Another is Mr. P.K. Ratha.
My lord, on behalf of Mr. P.K. Ratha, we have no instruction in this one.
All right. So in the third petition, you say counsel petitioner states he has no instructions. The petition is dismissed. Second petition, you say in view of the order passed by this court today in writ petition civil 10279 of 2003, the present petition is also disposed of. All pending applications stand disposed of.
No, 11883. It's a different issue.
What is it?
11883 by 2010 law. Here, in fact, an appellate order is under challenge. Obviously, revision is available.
Then he has to file a revision.
All right. 11883 of 2010, you say counsel the petitioner seeks leave to withdraw this writ petition with liberty to avail the remedy of a revision petition before the member Board of Revenue.
One thing, because what is the problem? What is creating the problem, my lord here? Kindly have a glance. Because the OEA collector's order I have annexed, that is at annexer 11, page 43. Let's me kindly have a glance at page 45 of the brief. I'm reading the one part of the order. The most important point of this case is, let me kindly have a glance, that the opposite party, though asked to produce the said lease patta dated 5/3/1944, basing on which the TL number 198 of 11 stands reassessed, it is clearly proves that either such illegal lease patta is not in existence or the opposite party intentionally suppressed the same. On the failure of the opposite party, adverse inference can be taken against the opposite party. Lord, to this TL number 198/11 is a document of the Tahsil. I applied for the copy. Kindly have a glance at page 42. What they are reporting. In page 42, I have submitted the application in portions of which my prior are rejected, saying that the document is not available. And nevertheless, an adverse inference is being taken that this document is not being produced by me. It's a record of the Tahsil. That may be because unless that is directed, same document on the basis of which my records were corrected.
You say it will be open to the petitioner to file an application before the revisional authority to ask for the original records to be in possession of the authorities to be produced,
including the tenant's ledger.
Original records, including the
tenant's ledger, because that is the official document of the Tahsil.
Tenant ledger to be produced for perusal by the revisional authority as well as the parties.
Yes.
All right. The petition is accordingly disposed of as withdrawn with liberty is paid for.
Weekly list item number 12.
May I please, Your Lordship?
Yes, please.
My Lord, petitioner was the guarantor to an industrial unit, Your Lordship, which had held finance from Orissa State Financial Corporation. Both the units were adjacent, my Lord. The other unit belongs to my wife, Pankajini Panda, the connected writ petition, Your Lordship. I am Jairam Panda, my Lord, proprietor of Jyoti Vidyog Building Center. This was established, my Lord, and was functioning for after post-cyclone in 1999 for rehabilitation and reconstruction of the damages that the havoc it has caused. So, my Lord, in course of expansion of National Highway, our units were sought to be acquired certain portions. As a consequence, Your Lordship, the unit stopped running. And there was default for which my wife's unit came to be seized by the Orissa State Financial Corporation. While doing so, they also seized my properties, which are not mortgaged. There are two categories of properties involved here, Your Lordship. One property belongs to my wife, Pankajini Panda. 3 sale deeds I am talking about, my Lord. One is belongs to Pankajini Panda. Second is, Your Lordship, a property which was not mortgaged at all. And third was, I am the guarantor and that property was mortgaged. Now, I approached the sale notice issued by the Orissa State Financial Corporation because in course of, my Lord, seizing the unit of my wife, they seized my unit as well. That is Jyoti Vidyog Building Center, my Lord. Your Lordship, I have filed a date chart, Your Lordship, I kindly look at. 12/2/2004.
So what you're silent about is what is the amount you owe the OSFC?
I by myself don't owe anything. I am the guarantor, my Lord.
What is the amount owed to the OSFC?
That was then, my Lord.
Somebody has borrowed.
My Lord.
You stood as guarantor for whose loan?
That is broadly speaking, Your Lordship could be right.
You're still not telling us the amount.
I'm saying, my Lord. Straight away I can't answer because I can't give an incorrect statement, Your Lordship.
Who's appearing for OSFC?
Yes, madam. I'm appearing.
So you'll know how much he owes the, what is owed to the OSFC?
in fact, was
Even you
happened,
don't
my
know. You're not interested in getting back your money clearly.
Yes, yes. Well, what has happened, pursuant to your lordship directions on 17/2/2005, my lord, the lordship this Honorable Court directed, since the property was not mortgaged by neither by the loanee nor by the guarantor, the finance corporation was directed to release the property. That was direction dated 17/2/2005, and another direction was 22/2/2005. Pursuant to that direction, my lord, on 19/3/2005, my lord, the entire property was released in favor of the petitioner.
All right.
So
Then they sold it in 2009.
No. So far as that.
Then they sold it in 2009.
No cause of success.
That is why-
survives. So far as first writ application is concerned, madam.
There are three sale deeds I have annexed. Pursuant to your lordship's direction, they have released the property which was in my favor. Now they sell it in 2009. That is annexure 1, annexure 15, your lordship.
That part I have to take instruction, my lord.
No, where's the question?
Because
I don't
my
know
lord-
how he is saying that it is becoming.
That's one of the main reasons why he has come here.
Yeah, yes, my lord. Because the records are not with me, my lord.
And for the auction purchaser, my lord.
Yes.
OP number 5 in the first writ petition and OP number 3 in the second writ petition. That is connected. Something pertinent, my lords, I want to draw your lordship's kind attention. Lordship may kindly see, I have filed my counter. Lordship may kindly see internal page 7 of my counter.
Your
that
stone hope,
my lords,
represented
running
by
page 108.
Anantaram Mahapatra.
Mine. So, lords, I purchased the properties. Lordship may kindly see annexure A/5. A/5 to my counter. Now, same property, lords, your lordship will find from annexure H/5. H/5 at page internal page 26 of my counter. Page that would be running page 127 of the brief.
You're again selling the same property.
Same properties. Lords, probably he has obtained, both the husband and wife obtained loan from the Bank of Baroda, and that was property was the bank was lien over the property, and that matter went to the DRT. Lords, I'm the auction purchaser. I purchased the property from OSFC.
What was the year in which you purchased?
My lords, 2009. Total outstanding, lords, that is in respect of land and building, that is 4 lakh.
It was 14 lakh something. 14
4
lakhs.
lakh 60,000, and the collateral, lords, it is 6 lakh 70,000. Page internal page 12, annexure D/5, internal page annexure E/5. I filed the.
So today the situation is he has got back the property, although it has been sold to you. You have not been put in possession. Have you been put in possession, sir?
I've been put to possession, so I'm in possession.
He says
No, I've said in my counter.
Oh, you're in possession now.
I'm in possession. I've invested a huge amount of money.
Orissa State Financial Corporation released the property in my favor in 2005, your lordship, pursuant to my lord's direction that it is not mortgaged.
No, releasing in your favor is one thing.
All the documents were returned to me, my lord.
You are not put in possession.
I was put into possession.
Everybody can't be put in possession, sir. Now don't go on in circles. Yes,
that is on record, my lord.
It's a question of passing on title as well, lordship. May I appreciate.
Let us first be clear on something, sir. Today he is in possession or not?
Today he is in forceful possession, my lord.
That is different. Anyway, he is in possession since 2009.
2009.
12 years he is in possession.
I have questioned his possession, my lord. Your lordship question?
No. So for 12 years he is in possession now.
He was, yes, as of now he is in possession, and that possession he was put in by the Orissa State Financial Corporation.
Correct.
Orissa State Financial Corporation had no business to do so, my lord, because this property was not mortgaged, and they had released it in my favor, pursuant to my lord's direction. And in any case, second
What
part,
is their explanation? Why did they sell it?
they have not filed any counter to that, Your Lordship.
Lords, my role comes after 2009 only.
How is he to blame? That's the whole question. What is his mistake in this? He's parted with valuable money. He's got possession of the property.
There, Your Lordship, he is purchasing a property. He should have been careful whose property it is.
Why careful? It's being published in the newspaper.
My Lord knows, and
OSFC is publishing the advertisement with public
I
notice.
intimated OSFC, my Lord, that don't sell it. If this honorable court has said that it cannot be sold.
Was
without
there
leave
an
of the court.
interim order restraining them from selling after the auction notice? Did he file a contempt? Sir, did you file a contempt petition?
I came, my Lord, in amending the writ petition. I challenged that, Your Lordship, before my Lords, questioning the sale deeds.
2005. That is in 2016.
17.
Who says? Amendment was much later, much earlier. Your Lordship, the order passed was, sale shall not be finalized without leave of the court. That was there in 2009. When I came to know about the sale and all that, my Lord, Annexure 12, I gave them a letter by registered post, speed post, my Lord, Annexure 14. That was on 11 to 2009, my Lord, page 65. I am to inform you that my husband such and such filed a writ application before Honorable High Court, WPC number 13898 of 2003, and Honorable High Court passed a stay order of miscase number such and such, stating that sale of the land, building, machinery of Jyoti Udyog building shall not be finalized in favor of any party without leave of this court. Subsequently, on 17 to 2005, Honorable High Court directed you to release the property standing over the khata number such and such, which has been mortgaged, which was not mortgaged in favor of OSFC. Accordingly, you have released the said landed property along with other assets by your letter dated 12/3/2005, and my husband received the same on protest. After receipt of the assets, my husband Joyram Panda submitted a loss statement of such and such amounting to 1,43,054 such and such, along with interest 1,43 lakhs, along with interest and such. Onwards, till final payment of copy has been acknowledged by your Barampur branch, and the same has not yet been paid. Since the submitted loss statement file such and such, my Lord, then I'm skipping that portion. Jyoti Udyog and Paul daily dated 12/2009, it not only violates the court's order, but it illegal or arbitrary in law and loss of image, as well as seizure of assets. Consider pay me the loss.
Interim order passed on 5th February 2015.
My
The
Lord?
interim order dated 5th February 2015.
Yes, Your Lordship.
So that interim order is only to injunct the auction purchaser from further transferring the property.
Your Lordship is referring to which order, my Lord?
2015.
2015 order. That was a letter, my Lord. The original order was 12 to 2004.
Sir, I am asking you to read an order. I've repeated the date thrice into this mic. If you do not listen, I cannot help it, sir.
My Lord.
Kindly come to the order of this court passed on 5th February 2015.
Yes, that restraint order is there. I am conscious of that, Your Lordship. Not to create third-party interest.
Yes.
Content, I have no instruction. Content file is like bachelo.
What is your stand, sir? OSFC. You've created all this mess. What is your stand?
Take instruction in the matter because
Can't go on taking instructions, sir. What you have to know, this is a final hearing of a petition. You can't say I want time for instruction.
I've sought for instruction, my Lord.
So we'll simply allow the petition then. We'll ask you to pay damages to everybody. Damages to him, damages to the auction purchaser. First of all, there is no question of going after this property. He's a guarantor.
Yes.
You could not have invoked section 29. This must have happened through section 29.
Yes,
There's
sir.
case law to say you can't touch guarantor's property under 29.
Let's come on 17th, my lord, take it. 17th, my lord, because no documents are there with me, my lord. Because
Sir, you speak in the mic. I keep shouting into the mic. You people don't think it's necessary to speak into the mic.
Sorry, my lord.
Even if I speak into the mic, you keep on asking yes, yes, yes. The same question you keep asking thrice, 4 times.
Sorry, my lord, sorry. My lord, I have no documents, my lord, supplied by the corporation because I've been, they have engaged me on.
So the corporation specializes in engaging people without giving them documents, without giving them instruction. Just engage. Go and appear in the High Court. We will not give you instruction. We will not give you papers. We will not file counter. Somehow you argue the case.
In 2009, my lord, another council was engaged. He was disengaged in 2009. Thereafter, no engagement was given, my lord. That is, they have told me yesterday. They have given me Vakalat Nama, my lord.
They are very, very nice of them, sir. We
Sorry,
should
my lord.
give them a special medal.
No,
I'm
very sorry.
They are
for-
being so kind to the High Court. So you get it in trickles. You first get Vakalatnama, then for instructions you will take adjournment.
No, my lord. Yesterday I told
then
them.
for filing documents you will take time.
I've told them to supply me documents.
Then for counter affidavit you will take some more time.
They expressed that they told me that no documents are found in the office, my lord. That's why they told me to get the document from the council, my lord.
It's really shocking.
Very sorry for.
I think you pay costs, sir. I think the best way to bring all you people for today's adjournment, you pay 20,000 costs to each council. All right. And actually, you should pay costs even to the Legal Services Authority. You see, this writ petition has been pending since 2003. And one of the main grievances is about the wrongful actions of the Orissa State Financial Corporation in seeking to bring a guarantor's property to sale by invoking section 29 of the the State Financial Corporations Act, bracket SFC Act, when that is clearly proscribed as explained by the Supreme Court of India in, so give us that there are 2 or 3 judgments.
Yes, my lord. Yes.
2008 Supreme Court 1797.
2008 AR 2008 Supreme Court. Just give it the cost title, sir.
State of Kerala, my lord. Karnataka State Financial Corporation versus N. Narsimha and others.
Karnataka State Financial Corporation versus
N. Narsimhaya and others.
Narsimhaya and others.
Year 2008 Supreme Court 2177.
1 minute. What have we noted down? No, AIR, sir. Page number blank. AIR 2008 SC
1797.
For the first time you're speaking clearly into a mic. All right. Sir, my only request to all learned counsellors, please use the mic. Speak clearly.
The other day, your lordship, I was saying this is.
And when I speak into the mic, you keep on asking. I don't know what. Am I audible or not audible?
Yes.
When I watch the live streaming recording, I am very audible to everybody. But the council keep on asking same question again. When the same question is asked by Justice Pattanaik, they answer immediately. So I have decided that only I am ununderstandable and inaudible. All right. You see, right. At one stage, this court had by an order dated 17 February 2005, directed the property in question to be released in favor of the petitioner Full stop. It appears that after a few years, that same property was put to sale by way of public auction. Opposite party number 4. No. Opposite party number 5. Messrs. Stone Hope, represented by its managing partner, Shri Anantara Mahapatra, was the successful auction purchaser of the property in question. This led the petitioner to amend the writ petition, challenge that auction sale. However, somehow in the meanwhile, the auction purchaser was put in possession of the property in question by OSFC, leading this court to pass a further interim order on 5th February 2015, injuncting opposite party number 5 from transferring the scheduled property and creating any third party interest in the disposal of the writ application. Paragraph. Even during this time, no reply was filed by the OSFC. Paragraph. Today, when the matter was called out, while counsel for the petitioner and opposite party number 5 are ready with their arguments, Mr. Amitav Das, appearing for OSFC, says that it is only last night that OSFC decided to issue sign a wakalatnama appointing him to appear on its behalf. Full stop. He has no instructions. Full stop. He has no documents. He does not have the paper book. Full stop. He is therefore not able to make any submissions. Full stop. As a result, he is asking for an adjournment in a 2003 petition. Full stop. Paragraph. For necessitating today's adjournment, OSFC will pay costs of rupees 20,000 each to the petitioner as well as opposite party number 5, and also deposit rupees 10,000 in the Orissa State Legal Services Authority. Full stop. Proof of payment of these costs will be placed on record not later than 4th April 2022. Full stop. The OSFC will by that date file its affidavit giving a para-wise reply to the writ petition and enclosing all relevant documents. Full stop. If the OSFC fails to comply with any of the above directions, its managing director will remain personally present in the court on the next date. Full stop. List on. Rejoinder to the above affidavit be filed before the next date. List on 18th April 2022.
The petitioner may be directed to serve a copy of the writ application.
No, we are not going to say anything, sir. We are not going to say anything. If OSFC doesn't get his acts together, next time the managing director will appear before us.
Yes.
You tell him we'll double the costs or triple the costs.
Yes.
We will not hesitate to do that. You're treating this court so casually.
No.
I'm shocked.
Yes.
I'm shocked that the OSFC thinks it can get away like this. Yes.
Weekly list item 13.
Yeah, Your Lordship, in this case, I have challenged the notification under Annexure 1 that under Land Acquisition Act of year 2002. I want to draw your Lordship kind's attention, my Lord. In this writ petition, I have taken two grounds that the sealing proceeding over such proposed land is pending for adjudication, and so therefore, my Lord, land acquisition proceeding cannot be adjudicated at this stage. That is one. And second, that is this notification is against CRZ notification, that coastal regulated zone, because proposed land is within the high tide line that within Puri town. So it is prohibited that as per notification, any construction is prohibited because this land acquisition is proposed land acquisition is for industrial purpose. But your lordship, that second ground that I have taken that against his CRZ notification, that local residents of Puri town had
1 minute,
already.
madam, before you proceed,
your lordship,
Annexure 1 is a notification dated 31st January 2002. Correct?
2002. My lord.
When did you file the writ petition?
2005.
What is your explanation?
My lord, I am coming, my lord. So another writ petition that is already been dismissed and 30/11/21, that is 110/725 filed by local residents, my lord.
So far as that's already dismissed. This has to go.
My lord, you are challenging the same notification, but in
the
this
very same notification,
very same notification.
Challenge the present petition. Writ petition civil.
Writ petition 10725/2005.
10725 of 2005 was filed by the local residents. That writ petition was dismissed by this court on
30/11/2021.
30/11/2021. Accordingly, the present writ petition is also dismissed.
Weekly list item 14.
Not pressed, my lord.
Counsel, the petitioner states the petition is not pressed. It's disposed of as such.
Weekly list item number 15.
And item number 15, no instruction, madam.
No instructions.
I'm appearing on the opposite.
Disposed of all the matters.
Weekly list item number 16.
Item 16, may I pray your lordship, this matter has become infructuous with the
This petition has been rendered infructuous. Disposed of.
Obliged.
Weekly list item number 17.
None appears. Dismissal not possible.
Weekly list item number 18.
None appears. Dismissal not possible. The court finds that the issue concerns family pension. The respondent was already 62 years when the present appeal was filed way back in 2007. Considering the long passage of time, the court considers it appropriate not to interfere even on merits, while leaving the question of law arising from the impugn order open for decision in some other appropriate case.
Obliged.
The appeal is therefore dismissed with the above observations, both on the ground of delay as well as on merits.
Weekly list item 21.
And for OP 6 and 10, already I have complaints to your lordship's last order. I have already filed the additional affidavit.
Union of India.
Union of India.
Give me a copy.
I already sir.
Where is that?
Public interest litigation so far as Shishupalgarh and legal site is concerned.
In the last order, your lordship has directed the Union of India to file the affidavit.
Correct.
And he's saying that he has already filed it.
Oh, I see. Where is that, sir?
21.
6 and 10, correct?
Yes, ma'am. 6 and 10.
It's there. Additional affidavit.
Yes, ma'am.
Mr. Arun Malik.
Yes, ma'am.
Shishupalgarh.
My lord, yes, total area is 562.681 acre land. But so far as the demarcation is concerned, only 0.76 decimal has been demarcated. That this small piece of land has not been encroached by anybody. But other parts has been encroached. I have already annexed the photographs, which your lordship's earlier order has specifically directed annexed and photographs of the monument sites. State government has filed the affidavit without annexing the photographs.
Photographs are with me. Photographs are with me. On that day, I wanted to file it, but your lordship has said that it will be filed on the day. Photographs are with me.
Entire area is protected area. And entire area has to be evicted. The eviction process to be carried out by the state government, state authorities.
What is this ZCB machine?
JCB.
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 Yes, yes.
Oh, typed it as ZCB. So one of the main tasks, Mr. Monty,
Yes, ma'am.
is demarcating the entire area of 562 acres.
Yes, ma'am.
Not just 0.775 decimal of
But the
Sisupal.
direction was only for that particular area, the boundary wall is to be constructed, so demarcation is required. So,
No. So the entire he says
that is
entire
what I have. Your Lordship may kindly see, look, para 10 of my affidavit dated 21st June 2021. Now it appears that the ASI is filing affidavit adverse to state affidavit. So I have not I have not received any copy of this affidavit. It's not find place in my file also. Let me respond
this
to
will mean that everything around Sisupal Gar will also have to go. But they're all densely constructed areas, no?
Since 2006, I have repeatedly communicating to the state authority. And state authorities are allowing the electricity, the roads, every facilities has been given. Therefore, they are constructing the area. Any construction is illegal in view of the act. And
No. Since when
now,
have these
now
constructions been there, sir? Since when have these constructions been there?
Since
नहीं देखो रिसिप्ट
in this case, I have also filed the preliminary objection in 2006, wherein I have annexed several letters. We have communicated to the state authority. That is in view of the rules. That is section 19. This 19.2. The central government may, by order, direct that any building constructed by any person within a protected area in contravention of the provision of subsection 1 shall be removed within a specified period, and if the person refuses or fails to comply with the order of the collector, may cause the building to be removed, and the person shall be liable to pay the cost of such removal. That is our role is only confined with to intimate the collector. Collector has to take the proceeding for removals. That in spite of several communications also.
May I suggest one thing to me? I have filed an affidavit on dated 21st June 2021, and I will serve copy to him.
Yes.
And he has filed an affidavit yesterday or day before yesterday.
No. This is quite some time ago, actually.
But copy has not been served on me. I will file response to his affidavit and let him file response to my affidavit.
He has filed it on 24th December, sir.
24th December.
Yes.
But copy has not been served on the state because it is now it appears that there is this affidavit is adverse to the state stand.
Yes.
Then you have to serve a copy and I should be given opportunity to respond to that.
An affidavit dated 24th December 2021 has been filed by Shri Arun Malik, presently working as superintendent archaeologist with the Archaeological Survey of India, bracket ASI, bracket Bhubaneswar Circle. Full stop. Inter alia, one important point being made in the affidavit is that protected area in terms of the gazette notification dated 13th November 1950 is to an extent of AC 562.681 Full stop. The said notification was issued under the Ancient Monuments Preservation Act 1904, subsequently reenacted as the Archaeological Monuments and Archaeological Sites and Remains Act 1958, bracket AMASR Act, bracket. Further amended as the AMASR, bracket Amendment and Validation, bracket Act 2010. Full stop. The site is a centrally protected monument full stop. It is accordingly submitted that this entire area requires to be demarcated and a boundary wall constructed consistent with such demarcation. Full stop. It is stated that what is sought to be now demarcated is only the area of Sisupalgarh, whereas the area to be demarcated and protected is much, much larger. Sisupalgarh, bracket, which is only 0.775 decimal.
Yes, ma'am. 775.
Bracket, whereas the area to be demarcated is much, much larger. Full stop. The ASI has enclosed with its affidavit copy of the site plan indicating the protected area, the photographs of the ancient structure located in the protected area, and the rampant construction of illegal buildings, for the removal of which, according to ASI, it has been constantly writing to the state government. So it is urged the affidavit that the authorities are required to exercise the powers under section 19(1) and 19(2) of the AMASR Act to stop construction of buildings within the protected area. While according to ASI, it has taken effective steps for constructing a boundary wall around the protected area at an estimate cost of rupees 81,03,971, the work of such construction can be taken up and completed, open quotation, only after removal of encroachments found within the protected area, unquote. Mr. D.K. Mahanti, a copy of the above affidavit, Mr. Mahanti, learned AGA, states that the copy of the above affidavit has not yet been served on the state government. Full stop. Learned counsel for the ASI states that he will do it today itself. Full stop. Mr. Mahanti seeks and is granted 2 weeks' time to respond to the above affidavit.
4 weeks' time.
4 weeks' time to respond to the above affidavit. the state government must come up with a concrete plan, with a detailed plan on how it proposes to go about enforcing the aforementioned gazette notification by removing encroachments and facilitating the construction of a boundary wall around the demarcated area, which has been notified as a centrally protected monument.
In that respect, we will file the sketch page, my brother. That sketch
Yeah,
page
I've
will
already
be
noted that. I've already noted that.
Obliged.
List on.
Well, let him be directed to, let the central government council be directed to file a response to my affidavit dated 21st June. Because in that affidavit, I have stated that our liability is confined to certain, that let him.
Certain area, they have combined certain area, but it is not a fact. We are
that you have to come up with an affidavit that it is not a fact.
Everything in this affidavit. Sketch page in this regard.
List on 16th May.
List item 22.
Your Lordship, I am on behalf of Learned Senior Counsel L. Pangari. There is no instruction from the petitioner in this matter, Your Lordship.
All right. Counsel petitioner states he has no instructions.
I'm for the opposite party.
All right.
List item 23.
23 has become infructuous, my lord. Both
Counsel petitioner says the petitioner has been entered infructuous. It is post of research.
List item 24.
Item 24, I am for the petitioner, Your Lordship. I have no instruction, Your Lordship.
No instructions.
List item 25.
Right, please, Your Worship. There is a noting, my lord, that notice could not be served on the opposite party number 2 owing to shortage of stamps. But my record shows that the deficit stamps were given as early as in 2009. This is a matter, my lord, where the opposite party number 2 was the workman. He was directed to be reinstated. He was removed from service after disciplinary.
So no 17B also.
Hello?
No 17B. No service of notice. Nothing. Workman gets nothing, sir. How old is the workman?
That I was in fact checking up. I didn't find his age anywhere. Let me take fresh steps, my lord.
No. Not at this stage, sir. Sorry.
That's right. I make my submission.
This is a matter filed in 2008 in which notice was issued way back on 23rd December 2008. So, finding that the court is informed that requisites had been filed and on 16 September 2009 granted an unconditional stay of the Labour Court Award dated 29th February 2008. Full stop. As it transpires, the notice could not be issued to opposite party number 2 workman due to deficiency in postal stamps. Full stop. No effort has been made in the last 12 years to have the deficiency made up and for fresh notice to be issued. One opportunity was granted to the petitioner by this court on 29th April 2015, and yet the deficit postage stamp was not filed.
Your Lordship, I record my statement that on 27/10/2009, deficit stamps were given.
No. 29th April 2015, you were given time, after which you have not done it. The court does not propose to give any further.
How will I know, my lord? There is
Time.
no.
So we've all been lawyers. We go and follow up. We go to the registry. We find out what's the current state.
My lord, after the requisites were filed, again I will go to the office and to find out whether the requisites are there.
That is what I did as a lawyer. I can only share my experience with you. I know you're much senior to me. But I used to do this as a lawyer.
Malad,
Because I'm very keen that if I got a stay, see, we used to follow the, what is that? Order 39, 4A, is it? 3A. That was the principle dinned into us, that stay will get vacated if you do not ensure service of notice. In 226, we never bother about those things.
that is true, my lord, but unless
As lawyers, we were very keen on these things somehow. I mean, that is the chamber which I joined, all this was very clear, very dinned into my head. That stay will get vacated if you don't make sure that service is complete.
that is correct, my lord, but provided no, what can be done, my lord, once the office doesn't list it and we do not know what will be stamp.
So everything is
You'll
the
also
court's
kindly appreciate one practical
so everything is the court's fault.
My lord, your lordship
There's
will
no
appreciate-
fault of the lawyer. Everything is the court's fault.
in every given case, different status will be there. I don't say anything. I don't want to stand to controversy in this, but I will only submit one thing. Suppose we file the stamps today, after weighment, and we file the stamps, and the office doesn't send it to the post office for 15 days. Thereafter, some change in the stamps. Then how will we know whether that change is required to complied with? But dismissal of a matter on merits is another thing. This is completely a blame on the council, my lord.
All right, you argue on merits.
Anyhow, I'm
You
very sorry.
are the victim. We are the oppressors. You are the victim. All right, you argue. And like I told you, it's always the fault of the court. It's never the fault of counsel. So we will accept that, and you argue the matter now. Please argue, sir.
My lord. The short date chart I have prepared, my lord. Annexure 14 is the order by which
So you have no problem arguing it without the other side being served, because that also you will say it is the court's fault, correct?
I have made a prayer that
This
I
is
will
a
be-
case against the workman.
Yes.
You are not serving the workman.
That is
For you, that doesn't matter at all.
No, I have made a prayer in
Once
the
you
beginning.
have filed a deficit court fee for service of notice, that your job is done.
My lord, before
All right.
starting the case, I made a prayer that I may be permitted to take a fresh notice, my lord. It's not that.
So
I'm
in a
circling away to-
226, in a 2008 writ petition in the year 2022, when counsel says, I forgot to do what I was supposed to do in 2015, the court has to be indulgent and to say, yes, sir, it is only the court's fault. It's not the counsel's fault. Again, fresh notice. Anyway, carry on, sir, carry on. Yes, tell us, sir.
But as early as in 22/5/2004 to 14/6/2004, the workman who was an assistant of the operator, film operator, was remained absent. You will also kindly turn to on 15/6/2004, he gave a reply saying that I am sorry. In the last page of this note, I have given the
Carry on, sir, carry on.
last page of the note. I have given the English translation of the page 10.
Yes.
The manager Asoko Taki's apology letter submitted by M. Bhaskar Rao, cabin helper.
Right.
Sir, I remained absent from 22/5/2004 to 14/6/2004.
Right.
Without intimating you, I did not attend the duties.
Right.
Although you could have removed me from service for so many days, you being kind on me did not remove me. In future, if I do so again, you may remove me from service. He has admitted that he remained absent. Then thereafter, on 12/5/2005,
He again, when he remained absent, a letter was given to him to join immediately. That is by registered post. Postal acknowledgement is also there at page 11 and 12. Then he received the letter but did not report to duty nor responded to the letter. Thereafter, charge sheet was given for issuance for action for absence from 19/12/2004, calling upon him to answer the charges within 48 hours. He gave a reply admitting the absence, but explaining that due to his illness, he was absent. Thereafter, an inquiry officer was appointed and he was informed that your explanation is not satisfactory because you have admitted the absence, but given the explanation that you are ill. Then inquiry officer wrote letters on 6/2/2005. He did not respond to the letter. On 26/2/2005, the inquiry was completed ex parte and inquiry officer sent a letter along with the report. He was asked to show cause why he will not be given the punishment. Then the same was also sent to the DLO, Deputy Labor Officer. Challenging the order of dismissal, he filed an objection and presiding officer passed the impugned order, wherein it was held that the inquiry was not properly, he had no proper notice regarding the inquiry, and the inquiry officers should have probed into the matter by inquiring from the hospital as to whether really he was suffering, and with these grounds it was held that he should be reinstated. The impugned order starts at page 31 of the order mirror. I will just point out 2-3 findings of the learned PO. At page 31 it starts. At page 35, he says that the inquiry officer of receipt of the charges must issue notice to the delinquent for his appearance. And he says that no such document seems to have been furnished to show that notice was given, although notice was by registered post. Then, my lord, when the delinquent has not appeared, he finds fault with the management, saying that newspaper publication should have been given at page 37. Then at page 38, he says that the inquiry officer should have called for the OPD register of the relevant hospital or examined the concerned doctor who had granted the certificate in order to ascertain the genuineness of illness. My humble submission before our lordship is the moot question before the court was whether there was an unauthorized absence. If at all he is ill, my lord, it is admitted that he has not intimated and therefore the absence becomes unauthorized. And he did not appear before the inquiry officer, nor did he raise any ground to show that he was not unauthorizedly absent.
All right, orders reserved.
Weekly list item 26.
May I please, Your Lordship. And here the impugned order is at annexure 4. By the impugned order, the land appellate authority, that District Judge Ganjam Gajpati, has been pleased to set aside the order of confiscation of a tractor and a trolley on the ground of non-compliance of Rule 4(2) of the Orissa Forest Detection Inquiry and Disposal of Forest Offences 1980.
What happened to the tractor?
Well, that has been confiscation of was done by the authorized officer, that has been set aside by the appellate authority.
No. But that operation of the impugned order was stayed by this court.
They have also entered appearance also.
See, the impugned order asked you to release the tractor in favor of the appellant.
Yes.
That order has been stayed with this court.
Yes.
Way back in 2008.
Yes.
14 years, what has happened? The tractor is still staying there
No, I don't have
without any use to anybody. The tractor itself must have been finished, sir, by now.
I don't have any.
Neither will you have any use for it, nor will he have any use. Successfully, you have achieved this result as a result of this writ petition. Why keep it pending, sir? You say the impugned order required the present
One
petitioner to
observation.
release.
May I place one observation so that it will be easier for my lord to dispose of the matter? Lordship, kind of page 38. Page 38, fifth line from top. That is the conclusion of the land trial court, land appellate court. Lordship, pass appropriate order. Because there are an admission by the government council. That also fact is also corroborated by annexure 2, that is the inquiry report. That was not done by the range officer. Statute provides that the inquiry has to be done by the range officer.
All right. The challenge in the present petition is to an order dated 6 September 2008, passed by the district judge Ganjam, allowing FAO number 7 of 2007 filed by the opposite party and directing release of a tractor and trolley which had been seized by the assistant conservator of forest Parlekumudi, in favor of the opposite party. Seized by the assessment by an order dated 20th September to 20th January 2007. Paragraph. While directing notice to issue in the present petition on 8 December 2008, the operation of the impugned order was stayed. Paragraph. In other words, for over 13 years now, the tractor has remained where it is, without being returned to opposite party and without being put to use by anyone. Clearly, the tractor must have depreciated and broken down to an extent where it can no longer be used. Full stop. In addition to this, the court finds in the impugned order the learned district judge has noted the submission of the admission of the learned government pleader that the inquiry to be carried out by the forest ranger in terms of rule 4(2) of the Orissa forest detection, inquiry and disposal of forest offense rules 1980 had not been carried out. Full stop. On that short ground, the district judge was justified in setting aside the order dated 20th January 2007 of the ACF and directing release of the vehicle in favor of the opposite party. There is no merit in the present petition. It is dismissed. The interim order stands vacated. After lunch.
May I, my lord, crave indulgence of my lord? One is matter where my lord, friend Mr. Sanjit Mahanti is there, my lord. Unfortunately, he is not available today.
Oh.
And Mr. Satyajit Mahanti was telling me that he'll mention. I have no problem in waiting, my lord. My difficulty is that if I wait, I cannot go away from my lord's court if any other matter is called.
Oh.
So if I am in my legs, I cannot come here, my lord.
Okay, which is this item?
41, my lord.
41 item, my
lord. A short date may be given, my lord. They were supposed to be filing a convenience file.
Within that day, we will file it, madam.
They will file it within whatever date, but short
Counsel for the opposite parties is stated to be in some difficulty.
Private opposite party.
Private opposite parties stated
For
to be
IOCL,
some
madam.
difficult today. List on. We'll have it in July then. 13 July.
Lots.
All right.
My lord, I hope it's not Friday.
It's a Wednesday. All right.
Weekly list item number 27.
My lords, item 27, I pray, my lords, Mr. Pradipta Mahanti, senior counsel, was appearing in this matter, but he is now counsel for the OPC, wherein OPC is also a party, opposite party. So yesterday only case has been transferred to Mr. Samit Das. I pray it may come on any date in the next week, my lords. It may be.
Whom are you for, sir?
My lords, I am appearing on behalf of Mr. Mahanti, senior counsel.
No.
PK Mahanti.
Are you for the petitioner or?
No, my lords, OPC counsel also.
1 minute. Who's for the petitioner, sir?
Petitioner, my lord, Samir Das. Mr. Samir
So
Das
let's first hear him. Where is he?
Today, he just requested, since yesterday only case was transferred.
No, I don't understand. You are for the petitioner or for the opposite party?
My lords, we were for the petitioner earlier, but it has been transferred only yesterday since Mr. Mahanti is now appearing for OPSC, wherein OPSC is the opposite party in this case. So yesterday only case has been transferred. Old file, I only pray day after tomorrow or any date next week.
I
Mr.
don't
Samir
understand,
Das
sir.
would be appearing for petitioner, my lords.
Where is he today?
For some difficulty, could not appear. my lords.
Everybody first. So you are making appearance on behalf of Samir Das to say he is not available. You are appearing on behalf of Mr. Mohanty to say he is not available. So you are an all-rounder now.
No, my
You
lords,
appear on all sides to ask for adjournment for everybody. One council, they are saving all their thing. For one council, will appear for all council to say adjourn.
because I
Let us have the benefit of seeing Mr. Samir Das.
pass over, I will just inform him, my lords.
Otherwise, you will have to file a restoration application. I'm telling you that.
My lords, may pass over, I will just inform him. my lords. He will appear.
Yes. Pass over.
My lords.
Weekly list item 28.
But it has become infructuous, my lord.
Counsel, the petitioner states the petition is infructuous.
Weekly list item 29. Item number 29, weekly list.
29, I'm appearing for the opposite party, my lord, National Health Mission.
All right. None appears to dismiss.
Weekly list item number 30.
None appears. Dismissal not possible.
Weekly list item number 31.
On item 31, there is a defect, my lord. That defect causes in 2009, and finally, by virtue of your lordship's order, dated 22nd 4/2010, I humbly submit before your lordship that abates against opposite party number 2, my lord. Because I have not taken steps, that is the fault of the petitioner, my lord. I candidly confess before your lordship,
yes,
by virtue of the judicial order, and I don't claim any relief against opposite party number 2.
No, this is opposite party
Under
number
who?
4.
My lord, the fact of the case is that I was appointed under opposite party number 1 and deputed to opposite party number 2 for working, and thereafter repatriate to opposite party number 1. By virtue of that order, by the reversion order, which order I am challenging before your lordship, which is in Annexure 7, and opposite party number 1, I have sought copy on the very moment it was admitted. Extra copy I have sought in 2009. And today, till date also, they have not filed any counter. My humble submission before your lordship, I have challenged the order dated 6 September 2001, Annexure 7, page 19 of my writ application before your lordship.
Cancellation of deployment is under challenge, my lord. He was deputed to SIT. Thereafter, that deputation has been cancelled, and she has been directed to join in his parent department, that is School and Mass Education Department. That is the whole case before your lordship.
My lord, that I have challenged before the State Administrative Tribunal.
If your lordship will see the concluding paragraph of this judgment of the State Administrative Tribunal, that is at running page 23, internal page 4, my lord. It has been held that last, my lord, the government has a right to deploy its employees according to requirement of work. The applicant cannot contend that she had an overriding right to continue on deputation in SIT, my lord. As per the requirement, my lord, she has been deputed. Thereafter, she has been repatriated, my lord. And there is absolutely no defect in the decision-making process or in decision itself, my lord. That is my humble.
I humbly submit before your lordship what my learned friend says. If the order would have passed as per the deputation principle and rule of the government, my lord. I was deputed in 1996, my lord. And this order was passed on 6 September 2001. Neither, as per the rule, taken the consent of the opposite party number 2, nor.
No consent is required, my lord.
Yes, my lord, mandatory. Consent is required, and other things are required as per the deputation rules, my lord.
What
That rule
survives?
they have
She's been
not
working
followed.
with the SME department.
My lord?
She's been working with on repatriation. She came back or she did not
Yes,
come?
my lord, she must have been came back. my
What
lord.
is that must have,
My
sir?
lord,
You should
this
know.
is- My
What
lord,
is
this
must
is a
have?
year-old matter, my lord. Today it is listed.
So no need to find out anything about any case.
My lord,
Only after the case is called out, when the Chief Justice asks, one standard thing is I'll now take adjournment to find out.
No, my lord, I'm not praying for adjournment. You lordship may kindly appreciate my
And no counter has been filed, my lord.
So petition allowed because no counter is filed.
But no stay order is there, my lord. In this
All
case,
right.
no stay order.
I like all these submissions, sir. Nobody wants to get ready with matters. Nobody wants to find out actual facts. He does not want to file process fee for service upon opposite party number 2. Correct, sir?
Yes.
So very nice. So this is a repatriation order which is challenged.
My lord.
Which he failed in before the CAT, OAT.
State tribunal.
My lord, not repatriation, my lord. The repatriation is the principle of deputation. It is a reversion order, my lord.
All right. Whatever. You did not join.
Reverting me
So
to a lower cadre, my lord.
So your client went back home to relax, or she went and joined?
And she wanted to join and she challenged it before the.
So decided to relax after that.
No, I beg to submit. My lord, she challenged that before the tribunal. Tribunal didn't consider it. That's why again filed the writ before this honorable court. This honorable court said you have not rightly decided, remanded it back to the state tribunal. Thereafter, hurriedly, because the date was fixed to fix up the matter, to finish the matter in January, but they couldn't finish the matter in January. In April, they have finished with the same findings, same observation. And without applying the judicial mind, without considering my submissions and without following the deputation rules and principles.
Now,
that is my submission.
now are you in a position to
That is the
answer?
whole submission before your lordship, my lord.
Now are you in a position to answer the question?
My lord.
Do you know what question I asked you?
I beg to
So are you able to hear me now?
Yes, my lord.
The question is, did you join back or you did not join back?
My lord, she wanted to join back. She made a representation. But when she made a representation, she was given a posting order without any notice served on him.
Sir,
order served on him. And when she came to know that such an order has been passed, she received it in 2019, after lapses of 4 or 5 years.
No. This petition you filed in 2009, sir, correct?
Yes, madam. 2009.
Today we are in 2022.
Yes, madam.
So 13 years she's been sitting at home.
No, my lord. She came in 2014, my lord, to join. Let them file a
Sir, you don't answer the question. This is the difficulty, sir.
She came.
I'm desperate for an answer.
My lord,
I didn't ask you what did she do in 2014. I'm asking you from 2009, has she ever gone back to working or she's at home?
Yes, ma'am. I humbly submit. She gave her representation and also joining report. But she was not allowed to join there on the fact that an order has been passed transferring her to another place. But
Did you file an IA here saying, sir, I desperately want to go back and join? Please ask them to take me back. Did you file an IA here?
If your lordship will direct me,
How? Everything we have to direct.
Yes.
Very nice, very nice.
No, my lord.
Government servant has to be directed to work.
No, my lord.
By orders of the High Court.
If they would have filed.
Otherwise, government servant will relax.
No.
Relax at home. Don't worry. Lawyer is there in the High Court taking care of everything. One fine day when writ petition is listed, lawyer will tell the High Court, sir, my client is relaxing. Don't disturb her.
No.
Ah.
That is not my
Yes.
intention.
We will not disturb your client, sir. She's got so used to relaxing, she should continue to relax. How will the government work, sir, if this is going to be the fate? Just imagine, no stay order, no direction, nothing. You just relax at home. You have also been paying salary, or at least that was stopped? You don't know. You have to take instructions, correct? So in all probability, she's probably getting salary also. You never know. Do you know if your client is getting salary?
No.
No.
She's not getting salary.
Only that you know.
Because she was not allowed to join there, and she was told that you have given a letter to you, and she received it in 2009. Thereafter, when she wanted to join, they said, no, you can't join here. That is the subsequent changes.
She was 47 in 2009. It's close to 60 now. When is your retirement age?
My lord, she's close to 60. She's close to 60 now, my lord.
What is your retirement age?
60, my lord.
So for 12 years, a person who was supposed to be working as lecturer is sitting at home. You're not bothered. Have you even issued a show cause notice? No instruction.
No letter.
Perfect formula for indiscipline. Perfect formula. The challenge in the present petition is to an order dated 26th April, 16th April 2009, passed by the Orissa Administrative Tribunal, dismissing the petitioner's OA number 1406 of 2001. Full stop. By the impugned order, the OAT declined to quash an order dated 19 July 1999 an order dated 6th September 2001, whereby the petitioner stood reverted from the post of lecturer in production in the State Institute of Education and Technology, bracket SIET, bracket Orissa, Bhubaneswar. To join in the office of the parent department, that is Director Secondary Education / Inspectorate of Khurda. At one stage, the OAT had passed an interim order directing her reversion order to be kept in abeyance. This interim order kept getting extended till 10 January 2002. Full stop. When the OAT refused to extend the interim order, the petitioner approached this court by filing OJC 684 of 2002. The said petition was disposed of by this court on 10th December 2008 with a direction to the OAT to dispose of the OA itself at an early date. Paragraph. The OAT has an impugned order. Noted that the petitioner had been on deputation with SIET for more than 5 years. As rightly observed by the OAT, posts which are filled up by way of deputation are not meant to be a permanent avenue of employment outside one's own line of service. Full stop. There was no vested right in the petitioner to continue to be on deputation. Paragraph. In the present case, notice was directed to issue on 15 September 2009 to SIET, that is opposite party number 2. The requisites had to be filed within 2 days. Full stop. When nearly a month later on 12/10/2009, when the case was again listed, none appeared for the petitioner. So the court then passed the following order, reproduced the following order. Again, nearly a year thereafter, again, nearly 6 months thereafter, on 22nd April 2010, the petitioner was given yet another chance to file the requisites for notice to be served on opposite party number 2. Paragraph. Today, when the matter was called out, counsel the petitioner candidly admitted that despite 2 opportunities, requisites for opposite party number 2 had not been filed. And in terms of the order of this court, the writ petition ought to be automatically dismissed. Nevertheless, he insisted on arguing the petition on merits, which the court permitted him to. Having heard learned counsel for the petitioner, as well as counsel for the opposite party number 1, the court is not persuaded that the impugned order of the OIT suffers from any legal error warranting interference. Nobody can be insisting on, no one should insist on being on deputation indefinitely. The decision whether an employee should be reverted to the parent cadre after a period of deputation is entirely for the respective authorities to consider based on the exigencies of service. it does happen that on deputation, the terms may be slightly more attractive with higher perks. So that is not to say that when one is reverted to the parent cadre, one is being reverted to a lower post. Full stop. The petitioner was failed to make out any case to somehow continue on deputation. Clearly, the order reverting her to the parent department was a routine administrative exercise and nothing more. The court is therefore unable to find any error in the impugned order of the OET. The petition is accordingly dismissed.
Weekly list item 32.
Lord. Lord, here, my lord, I have entered appearance on 19/1/2022, my lord, for the petitioner, my lord. My lord, my name is not reflected. My lord, the matter relates to challenge to the order of a GRF and a ombudsman, my lord. My lord, here is a case, my lord, in 2004. This OP number 3, he applied for establishing his overhead line and a transformer. He was permitted. My lord, the power supply was effected in 2005. And subsequently, my lord, after lapse of 4 years, in 2009, he made an application to the Grievance Redressal Forum seeking that the amount what he has invested in the supply line for construction of line and a substation transformer, he wanted to get it back, my lord. And the GRF, my lord, without taking note of its power and jurisdiction, my lord, this the refund of a monetary claim, my lord, he has passed order to supply him the remunerative calculation after a long lapse of 4 years, my lord. And subsequently, my lord, he moved the ombudsman seeking implementation order of GRF, and ombudsman has said to implement the order of GRF. That is the subject matter of challenge.
You did not challenge the GRF order, sir.
My lord?
You did not challenge the GRF order.
Yes, my lord. GRF order was challenged, my lord.
Before
Here, my lord, GRF order is challenged.
Sir, not here. Against the GRF order, can you not go?
No, we cannot go to the ombudsman, my lord, because
No. Just come to page 19, bottom.
My lord, I lost sight this case.
Very nice, sir. You take the paper book from us. Have you found such a cooperative High Court, sir? We supply papers. You want decisions, barracks. We'll give you everything, sir. Only short of sitting with you on a conference and briefing you about arguments, we can do everything.
This your lordship stated the order of GRF under Annexure 1 and Annexure 2, my lord, order of ombudsman, my lord.
You are for the opposite side.
My lord?
No.
I am appearing on behalf of the opposite part of 3.
On 16/12.
I see. So tell us about your.
Kindly see page 20.
20.
He has not challenged the order of, kindly see page 20. Since the respondent has not assailed the impugned judgment.
So that is what I asked him.
Yes,
he seems to not be aware. He's saying, I have challenged it in the High Court, that is enough. So I asked him, why have you not challenged with the appellate authority?
No, my lord. There is no provision, my lord, to prefer appeal against the order of GRF, my lord. Your lordship may see 42(5), my lord. 42(5) empowers the consumer to make a grievance before the GRF, and against the order of GRF, my lord, he has further remedy to approach the ombudsman, whereas the licensee has no power to move to the ombudsman, my lord. That is, my lord.
Then which case the licensee should not indirectly do what it cannot do directly? Why should he let you challenge it here also then?
License cannot go, my lord. That is the bar under that provision, my lord. That is one under section 42(6), lordship may have a glance. Lord, where the consumer has a remedy, but the license has no remedy, my lord, than to prefer writ petition before this.
But you did not find a writ petition immediately. Only after the ombudsman passed on, you filed a writ petition here.
My lord, here consumer went to the ombudsman. My lord, simultaneously, my lord, when he moved there, we participated in the proceeding before the ombudsman, my lord. My lord, may see 42(6) says, any consumer who is agreed by non-redressal of his grievance under subsection 5 may make a representation to the for redressal of his grievance to the authority to be known as ombudsman. Even if he is not agreed with the order of the GRF, my lord, he moved the ombudsman, my lord, who has no power to entertain the same, my lord.
Where is this provision of
And
appeal?
similar order, an identical matter has been disposed of by the Honorable Court, my lord, where my lord senior was a party. My lordship taking note of all those aspects, the case has been disposed of, saying that GRF has no power to entertain this type of a monetary claim, my lord.
That is not correct. He has.
I will give the judgment, my lord. Lordship may call it tomorrow, I will give the judgment.
He failed to challenge the order.
Where is the provision for challenging?
Therefore,
Where is the provision for challenging? Under what provision could he have challenged?
if he is aggrieved by the order of the GRF, he could have challenged before the appellate authority.
Under which provision, sir?
Provision I have to. Well, let it come some other day.
So nobody is ready, sir. That's the best part. Only we are ready. We are ready with the case. We are ready with the paper book. Nobody else is ready.
Unfortunately, I missed it because my name is not appearing. That is why, my lord. I'll give the judgment. My
Actually,
lord.
your client has been so kind to the High Court, sir. At least they engaged you 1 week before. When did they engage you?
My lord.
When did they engage you, sir, to appear in the matter?
1901, my lord.
19 January.
My
A
lord.
long time ago.
But
Normally they engage that morning or the previous evening.
No, my lord.
No, this is very good. That's why I'm saying we have to appreciate your client.
My lord, I have missed it.
They've been
my
very
lord. That
nice
is
to the
why-
High Court. They've been very nice to the High Court. Only they forgot to give you paper book.
Lord, today, just in court premises,
I
I noticed
I
it,
know.
my lord.
We are not willing to let go of the case. That's the whole problem with us. We look at it, it's a 2009 case. We are in 2022. We don't want to adjourn cases like this. What do we do, sir? We don't like adjourning
My lord,
cases.
my lord, what I submit, one identical case was disposed of. My lord and senior was there for the opposite party, my lord.
We'll
He is
record
not-
both your
He
statements.
is suppressing that, my lord.
He's suppressing that.
Identical issue was involved, and what my lord said that I can go to in appeal or my lord friend also supporting that. But actually there is no provision, my lord. Our door is closed to approach the ombudsman, my lord, against the order
All
of the
right, tell
GRF.
us what is wrong with it now. Tell us. Tell us, sir. What is wrong with this order now? Tell us.
My lord, wrong is first of all, GRF has no power to entertain this type of dispute. Your lordship may see the proceedings. What are the proceedings to be taken up before the GRF? My lord, in that regulation, my lord, I will.
You don't have the regulation also. Very good, sir.
My lord, that book 130 in page 134, my lord, that electricity laws in Orissa book, my lord. My lord, there is proceedings. What are the proceedings to drawn up before the GRF? And it is this type of claim is not coming within that, my lord. Your lordship in that decided case which I am referring, my lord. Unfortunately, I am not with that, my lord. That honorable court has taken note of that and decided the case, my lord. I am very unfortunate. Electricity laws NC Mahapatra Bhaitan 134 proceedings before the GRF. GRF and Ombudsman Regulation 2004.
How this is prejudicial to them? The order passed to the GRF. How is it prejudicial to you, sir? How is the order passed with the GRF prejudicial to you? Just read the operative portion of the order.
The OP shall determine each of the parties share after calculating the remunerative scheme as provided in Regulation 13 of ORC Code 2004. And if the investment made by the complainant is found to be excess, then its share, the same would be
Only if it
refunded.
is an excess. So if it is not in excess, you don't have to refund anything.
This aspect.
What is the problem here? They simply asked you to assess what is each body.
It is not required to be assessed, my lord, after availing power supply 4 years, my lord. He has invested his own infrastructure, my lord.
Right.
My lord, lords may see what is the remunerative calculation, my lord, appendix, my lord, in ORC regulation, my lord. I am.
You collected an inspection charge. In fact, he paid 26,000 to you for inspection.
Milord, that
You
is
did
the
not carry out any inspection.
Milord, that is the inspection by the government of authority. Milord, electrical inspector is the government authority. Milord, he has to inspect the installation of the consumer. Consumer has installed the transformer and supply
come
line.
to the first page, page 15, third paragraph.
Milord, it is submitted on behalf of OP that since the OP collected supervision charges, it is the duty of the OP to get the line inspected by the electrical inspector. Milord, that aspect was
1 minute, sir. Kindly read. You seem to be now in a great hurry to finish the case.
Milord, the complainant having inspected, having deposited the inspection fees towards the inspection of electrical inspector, the same should be returned to the complainant. The further submission on behalf of the complainant that as per regulation 13 of OERC Distribution Concession Supply Code 2004, the licensee is to make the remunerative calculation in order to determine the share of the complainant and the licensee. Since the complainant has invested the total amount, the balance should be returned to it after deducting its share only. Here, Milord, the inspection, after the inspection is done by the electrical inspector, Milord.
Yes.
So power supply was provided in 2005. And in 2009, Milord, it cannot be said that the installation was not done and the license has not done the inspection through the electrical
Why
inspector.
can it not be said? If you have not done, they will say it's not done.
Well, how power supply will be provided, Milord? It must have been done. It was done.
Nothing.
Milord, it was done and power supply was provided without inspection, Milord, by the electrical inspector.
There is absolutely nothing prejudicial to
Milord,
you here.
Milord, electrical inspector is the government authority, Milord.
Yes, yes.
Without inspection, power supply cannot be a test certificate will be produced by the consumer, Milord.
Correct.
Yes, test certificate will be produced by the consumer and then only the power supply will be, will be declared safe and power supply will be provided, Milord.
All. Anything else, sir?
Milord, Lordship, I will show that the decision, Milord, which your Lordship have taken, Milord. Lordship, call it tomorrow, Milord.
No. We're not adjourning it, sir. We're not adjourning it.
Lordship, see what is the supervision charges, Milord. That is, he is liable to pay 6% supervision charges.
All right.
If the work is undertaken by the consumer, Milord,
right,
licensee is entitled to take 6% supervision charges.
Right.
I am placing that, Milord, the remunerative calculation sheet, Milord.
Yes.
Appendix 1, Milord. Remunerative scheme. An investment on any scheme of power supply shall be treated as remunerative if the revenue from sale of power is equal to or exceeds the cost of a power purchase, meeting the consumer's load, the cost of capital, depreciation, interest, and overall and maintenance expenses, Milord. When the consumer is asked to undertake the capital work, the estimated cost shall be calculated on the aforesaid basis. The licensee is entitled to get 6% of the total estimated capital expenditure towards the inspection fees, Milord. Milord, as per this provision, Milord, he has only 6% fees license has collected for the purpose of inspection, Milord. That is the inspection fees, Milord. To see that the installations are complete as per the standard norms, Milord. That is the 6% and all the balance the amount was invested by the consumer, so it is his own use, Milord, and it is his independent structure, Milord. Transformer, no other consumers are availing provided power supply from that substation. It is his own personal transformer, Milord, and he is to bear that, Milord, and accordingly he has done it, Milord. And after 4 years, Milord, the question cannot come, or he has no right to move the GRF. GRF has no power to entertain the same, Milord, because it is not coming within the scope of the GRF functions, Milord. Milord, that is, Milord, Lords may see the powers and functions of the GRF and Ombudsman regulation is there, Milord.
This point was not taken before the Ombudsman.
No, Ombudsman was not has not advocate. He is not the authority to sit over the order of the when the consumer is not agreed with the order of GRF, Milord. He has gone to the Ombudsman seeking implementation. Ombudsman is not the authority or the executing court, Milord. And Ombudsman, Milord, OERC under 142 of the Electricity Act, Milord, Lords may see if the consumer feels aggrieved that any order of the GRF or Ombudsman is not complied with, then he has right to move to the OERC, Milord, under 142 of the Electricity Act, Milord. 142 says, Milord, my lord, punishment for non-compliance of direction of appropriate commission. In case of any complaint is filed before the appropriate commission by any person, or if that commission is satisfied that any person has contravened any of the provisions of this act or the rules or regulations made thereunder, or any direction issued by the commission, the appropriate commission may, after giving such person an opportunity of being heard in the manner by order in writing, direct that without prejudice to any other penalty to which he may be liable under this act, such person shall pay by way of penalty which shall not exceed to 1 lakh rupees, or for the contravention of any of the case contravening failure with the additional penalty which may 6,000 rupees. Then, my lord, 146, punishment for non-compliance of orders or directions. However, whoever fails to comply with any order or direction given under this act within such time as may be specified in the said order or direction, or contravenes the attempts or abets the contravention of any of the provisions of this act or any rules or regulations made thereunder, shall be punishable with imprisonment for a term which may exceed for 3 months, with fine which may extend to 1 lakh rupees, or with fine or with both, my lord. My lord, here, my lord, if the consumer feels aggrieved with the order of the GRF, my lord, he could have moved the OERC, my lord, under this provision, which the consumer has not choose, my lord.
Consumer is not aggrieved by the GRF. What are you arguing, sir?
My lord, then
you
there
are
is
aggrieved
no-
with the
my lord, then
GRF
there
order.
is-
Where is the consumer aggrieved?
My lord,
Consumer has an order in his favor.
My lord, consumer is not, yes, my lord, order is.
Why should he go to the
No, my lord, where is
commission? He is happy with the GRF order.
My lord, consumer moved to the ombudsman, my lord. Consumer filed the approach.
Because you are not implementing. You've got all your
Ombudsman,
facts
my lord, ombudsman is not the
completely
authority
twisted.
to implement the order, my
All
lord,
right.
because
All
there is a palpable error committed by the GRF, my lord.
All right.
My lord, the consumer, instead of going to the ORC, went to ombudsman.
All right.
And ombudsman has also committed the same, my lord, by
All
not properly relying the what is the provision
Correct.
of law, my lord, under
Correct.
what provision the consumer is entitled, my lord.
Correct.
The ombudsman has passed order
Right.
that you comply this order, my lord.
Right.
This is not at all correct, my lord.
Correct.
In view of this provision, my lord.
Okay.
My lord, under this provision, my lord, there is no, the question does not arise, my lord, for a consumer, my lord, who has established his transformer, own substation and constructed the supply line. After 4 years, he will move to the GRF and seek relief in this type, my lord. My lord, this, my lord, lords may see under a particular provision, that is under section 142(5), my lord, 42(5), a forum has been established, my lord, and my lord, the certain powers are, ORC has entrusted certain power by the GRF to perform. My lord, what are those powers and functions, my lord? I will bring to my lord's attention to the provision, my lord.
No, whether there was any preliminary objection raised by you before the GRF?
Yes, my
regarding
lord.
absence
Yes,
of
my lord.
jurisdiction?
Yes, my lord.
What was the finding of the GRF?
My lord, my objection, my lord. My lord, my objection is, my lord, my objection is, my lord, annexure 6, page 28. Lords may have a glance. My lord, my lord, I am reading, placing it, my lord, I may allowed to place it, my lord. For the consumer, Mr. So-and-so is availing power supply of 3 MVA. My lord, so far para 4 is concerned, the estimate was framed by SESU on the basis of VR calculation, voltage regulation calculation submitted by the field officers. The consumer has expressed his willingness to do the work personally by depositing supervision charges. That is 6%, my lord. The party deposited 6% supervision charges amounting to rupees 26,000 and odd, by the MR number so and so in 2000, my lord, and rupees 4,500 by the MR number so and so, dated 30/12/2004, and rupees so and so on.
This was not raised.
The consumer has not deposited any further fees to SESU. The point raised, my lord, suppose raised under the para 6 to this complaint is baseless and false. The consumer power supply was given after execution of the construction work by the consumer. The estimate was framed on the basis of a VR calculation submitted by the field. So the question of remuneration calculation does not arise. As per SESU norms, similar, the consumer has to deposit 6% supervision charges when the electrical construction work is undertaken by the party or outside contractor as per the willingness. So it is not the responsibility of the CESU to get the work inspected by the electrical inspector. Necessary government fees should be deposited by the consumer for inspection of the electrical inspector. It is the government of Orissa authority. TOD software is uploaded in the meter on 12/6/2009. Necessary action is being taken to provide TOD benefit. That was the other benefit, TOD benefit, time of the day benefit. If the consumer avails power supply after midnight till 6 of the next day, that is called TOD benefit. And that was also replied, and agreement was executed, that was in 2000.
Did you understand the question of Justice Patnaik?
Yes.
You understood?
The objection we have raised before the GRF,
Have you raised? Have you raised such objections, sir?
It is not there,
So to answer this one line, you have taken 10 minutes to read the whole objection. All right.
Because I have not gone through this.
Very good, sir. Very good. So the challenge in the present petition is to two orders. One is an order dated 30th July 2009.
Unity is no more in existence
Passed by
since
the
last 4 years.
Grievance Redressal Forum in CSU, Cuttack. In CC case AED/57 of 2009, filed by the opposite party, seeking return of the money spent towards inspection fees of electrical inspector bracket T and D, and also to allow discount at 10 paise per unit for consumption of energy in the off-peak hours. Paragraph. The opposite party complainant was a large industrial consumer having a contracted demand of 2 MVA. Full stop. It had constructed a 33 kV line, spending rupees 472,320. Full stop. It had also deposited with the petitioner rupees 26,735 towards inspection charges. Paragraph. In terms of Regulation 13 of the OERC distribution bracket conditions of supply bracket code 2004, the licensee is to make a single quotes remunerative calculation unquote in order to determine the share of the complainant and the licensee. Full stop. The case of the opposite party was that after making such remunerative calculation, the balance amount, if any, should be returned to it by the petitioner after deducting its share. Full stop. On the aspect of discount, it was stated that although there was a static meter, the complainant should be given the benefit of a discount for consumption during off-peak hours, that is between 10 p.m. and 6 a.m. as per the tariff made effective from 1st April 2007. Before the GRF, petitioner appeared and filed a response, which is enclosed to the present petition's Annexure 6. Full stop. It was admitted that the opposite party had deposited a supervision charge of rupees 26,735. What is TOD?
Time of the day benefit. If the consumer avails power supply,
and action was also being taken to provide time of the day bracket TOD bracket facilities in the meter to record consumption for off-peak hours. Full stop. However, the petitioner was not prepared to make a remunerative calculation. Paragraph. Referring to Regulation 30 of the Supply Code, the GRF determined that the petitioner is obliged to make the remunerative calculation, determine the share of each of the parties, and in the event that the consumer had invested more than its share, that should be refunded. Full stop. The court finds no prejudice being caused to the petitioner by the above direction, since it is based entirely on Regulation 13 of the OERC Code of 2004.
Sorry, my
Full
lord,
stop.
that
Please do
provision-
not interrupt, sir.
I got
Kindly
it.
do not interrupt.
No, I got
My
it.
request is to you not to interrupt. Let us finish dictating the order. Then you please make your submission.
My lord, obliged.
On the second aspect of allowing discount at 10 paise per unit, again a direction was made to permit such adjustment to be made in the subsequent bills. Full stop. Paragraph. Learned counsel of the petitioner vehemently argued that the directions issued by the GRF were far beyond its jurisdiction, and that the GRF is not entitled to entertain these kind of matters at all. He made a reference to the Electricity Act, Section 46 of the 46, is it, of the Electricity Act?
45, 42, my lord.
42 of the Electricity Act.
42(5).
(42)(5), read with 42(6) of the Electricity Act 2003. Paragraph. The court peruses on perusal of the reply filed by the GRF before by the petitioner before the GRF, it is seen that no such objection was taken by the petitioner to the GRF adjudicating the complaint filed before it by the opposite party. Paragraph. As it transpired, since the petitioner did not implement the order of the GRF, the opposite party was constrained to go before the Ombudsman with case number 43 of 2009, in which an order has been passed by the Ombudsman on 19/11/2009, which again has been challenged in the present petition. Full stop. The Ombudsman has asked the petitioner to implement the orders of the GRF within a month. Paragraph. While issuing the notice in the present petition on 16/12/2009, the impugned orders were stayed. So for over 12 years now, that interim order has continued. Paragraph. With the petitioner not raising the objection as to maintainability of the complaint before the GRF, the court is not inclined to permit the petitioner to raise such an objection at this stage. Secondly, the court finds that the directions issued by the GRF are by and large consistent with Regulation 13 of the OERC Code of 2004, and therefore do not call for interference. The direction regarding extending to the petitioner the off-peak hour discount also does not appear to be unreasonable. Consequently, the court finds no reason to interfere with either the order of the GRF or the Ombudsman. The petition is dismissed. The interim order stands vacated.
This is circular prescribes what are the proceedings to be taken up before the GRF. My lord, this is new
You also
connection.
referred to a circular dated?
Circular dated, my lord, 19th October 2004.
Yeah, but you did not raise this objection, sir, before the GRF.
Those are the
But you
provision
did
of
not
law.
raise this
my lord.
objection before the
And
GRF.
my lord, moreover, the limitation aspect is, my lord, after
Sir, none
4
of these
years,
objections you raised before the GRF.
my lord,
None of the
limitation aspect
objections.
can be raised, my lord, here.
No,
So
no,
far
it
limitation
cannot.
is concerned.
We are not
Point of-
permitting, sir. These are all welfare measures for the consumer. You're arguing as if the consumer is such a powerful litigant.
No, limitation aspect, my lord. After
No,
4 years
everything
of
in good
availing
time,
power
sir.
supply, my lord,
Everything in good time.
there is no scope for
All
the
right.
consumer to move to the
Call
GRF.
out the
my lord.
next matter, sir. Call out.
Weekly list item number 33.
No instruction.
Counsel, the petitioner has no instructions.
Weekly list item number 34. Not pressed, man.
Not pressed.
Weekly list item number 35.
Contempt petition is also closed. This is separate contempt.
35, no instruction. 35, no instruction.
No instruction.
Weekly list item number 36.
Item number 36, Millers. I am for the opposite party number 1, 2, and 4. That is the bank, Millers.
Non-prosecution.
Weekly list item number 37.
Lord 37, I am here for the petitioner.
All right.
Lord, to assist your lordships, I have given a small affidavit today with a sequence of events.
All right.
Are your lordships having it, my lord? I have tried to.
Yes, we have it, sir.
Right. My lordship may kindly see in the writ petition, in the list, there are some matters connected to item 37. Lord, prior to my appearance, these matters were filed. Lord, I believe this review petition and the third matter, Lord, they are all duplicating the issue. So they will be depending upon the lead matter, that is the first one, which is on my lord's board.
Right.
Now, the first one, in a very nutshell, I can tell your lordship, OSFC sanctioned loan, Lord, 23,58,000. Now, against that sanctioned amount, your lordship will find from that note itself, they disbursed 19,89,340 to my client. That details of also I have given. Now, during this loan period, on my request, OSFC rephased the entire loan. So on refacement, your lordship kindly see, on refacement, the loan amount becomes 23,68,890. With interest, it becomes 36,14,303. They executed a refacement agreement. In terms of refacement agreement, I went on paying. them, your lordship. I'll just show your lordship that refacement order for your lordship's kind consideration. That is the only document your lordship will see. That is at page 22 of the first matter. 22.
Yes.
Kindly see that refacement order, page 23. These two refacement orders are there. Annexure 1 at page 20 and other is 23. Page 20 for the moment your lordship would kindly see. This is that refacement order. They have given the period through which, by which I am to pay the whole refaced amount. It is at 31st of August 06 to 20th of February 13. Am I clear, man? Kindly see this date. Page 20, Annexure 1. At the last column, 2, para 2, the date is available. These dates are all available.
So they've accounted for all that. On 23rd July 2012, you still owed them 25,29,000.
Let me just in a few lines I can tell your lordship what the OSFC has done here. OSFC allowed my refacement. The pursuant to their own refacement, they executed a refaced agreement, loan agreement. I went on paying that. I have paid sincerely this entire refaced loan account. Now your lordship sees when I was all throughout paying this, Annexure 4 at page 25, lordship would kindly see, they published a notice. 16th of February 2008, they published a notice under section 29, indicating my overdue. Kindly see page 26, 4.35 lakhs. Kindly see, man. And this amount also I have paid. I have given receipt along with the affidavit. It is already on record. 4.35 also I have paid. Kindly see on page 26. Page 26. Now my page 26 of the writ petition, this overdue amount, 4.35 also I have paid. I can cite those receipts I have filed today for your lordship, granted by OSFC. Now, once they refaced my loan account and 29 notice I have paid their overdue amount, suddenly even this 15 days period pursuant to Annexure 4 is not over, they cancelled the refacement of loan account. That without any notice to me, without giving any opportunity to me, why are you cancelling it? Kindly see Annexure 3 page 24, my lord. That 15 days period even not over, the refacement agreement which they have executed with me pursuant to an order, and I went on paying an entire amount, entire refaced loan amount I have paid, they cancelled it. That is the point for consideration, man. If the OSFC without giving me a notice, can cancel the refacement or not. Because refacement order they have allowed. I have paid portion to that. Lordship would kindly see that list of dates. I have given the dates of my repayments made. Kindly see. The whole 36 lakhs, 14,000 portion to refacement agreement, I have paid to them. Now suddenly, section 29 notice was given. Lordship may kindly see the date. 16th of February 2008, published on 18th of February 2008, indicating indicating the amount of default. Kindly see serial 23 of page 26, 4.35 lakhs. This also I have paid. Now this 15 days period granted here is not even over. This is section 29 notice. No notice to cancel the refacement loan account. Suddenly annexed 3 page 24. Kindly see, man. They have cancelled it without giving me any opportunity. And they have accepted the whole refaced amount from me. Now they are calculating portion to their own earlier loan agreement and coming out with a figure which is a very hypothetical figure for them, some 25 lakhs, 30 lakhs, which is not permissible in the eye of law. Kindly see, your Lordship would see annexure 3 page 24.
Yes.
Lord, kindly see annexure 3 page 24, my lord. Or this is order dated 22nd of February 2008.
Right.
Lord, this is the order I am challenging. Lord, I am saying that I may be permitted to place it, my lord. If your Lordship permits it, it's a very small letter. Can I place it?
Yes, yes.
Consequent upon your failure to pay dues of the corporation as per terms and conditions of the refacement as communicated by letter dated 6/2/2006, 5/7/2006. The loan agreement executed 6/3/2006. The refacement of the loan is hereby cancelled, and as such, other benefits so allowed are withdrawn. You are therefore required to pay the dues. Kindly see, my lord, pursuant to the refacement order, I am giving the details of my payments, my lord. It is there available on board. There is absolutely not a single default, and my period for repayment is available up to 2013. And they are cancelling it in the year 2000.
Rather come to the additional affidavit they have filed.
Additional affidavit.
They filed an additional affidavit. 23rd July 2012.
But kindly see, Lord, I'll definitely. This is that. Yes. Lord, this additional affidavit they have filed. It's a review petition. Additional affidavit dated 24th of July. Kindly see, Lord, where are they referred to this repayment repayments? They are again calculating the original loan.
No, they placed accounts accounting for all your payments, sir. The detailed accounts have been enclosed with this affidavit.
Lord, what I am trying to tell your Lordship is, my payment now has to be made under the refacement account, refacement agreement. Refacement agreement provides 36 lakhs of odd rupees to be paid by me as against 19 lakhs of loan. And I have paid the entire 36 lakhs. Now they have unilaterally cancelled the refacement and taking me back to the stage, pre-refacement stage. That's what the point is. How can they do it unilaterally, my lord? They have not given me a notice. They are not saying that they are cancelling my refacement loan account, loan agreement unilaterally. That's the point. Lordship will kindly see, my lord. They are not, and in this matter, Lordship would kindly see an order passed by this honorable court earlier. Kindly see that order. They are supposed to, kindly see the order dated 18th of April 2012. Kindly see, Lord. There is already an order in accordance with refacement agreement. Kindly see that order, 18/4/2012.
Yes.
There is already an order. The statement of accounts shall be prepared by the corporation in accordance with constitution-based decision so-and-so, reported in year 2001 Supreme Court. And
after this only they filed that additional affidavit, I think.
Look, this is the point. Now they are not saying that they have done it in terms of refacement agreement of the year 2006. That's the point, my lord.
Yes.
They are doing it. They are giving that entire statement referring to pre-refacement account.
All right.
Once they have allowed refacement, the outstanding I have indicated in my note 36 lakhs, my lord. Kindly see that note. If I have failed to pay any amount of that, I am liable to clear of the dues, man. Kindly see now. Kindly see this. In terms of refacement agreement, I am liable to pay 36,14,303. But I have given a statement, I have paid 36,32,726 to them. The entire statement is before my lords.
Yes.
Now they are not adhering to this refacement and coming out with a statement which is not in terms of the refacement agreement. That's the whole issue, man. That's the only issue.
What do you say?
My lord, for a moment, Lordship, may kindly see Annexure 4, page 25.
Yes.
We have given in the paper publication that the overdue amount is 4,35,000.
Right.
On dated 16 February 2008.
Right.
Thereafter, Lordship, may kindly see Annexure 3. The refacement letter has cancelled on 22/2/2008. And thereafter, today my learned senior has supplied a statement of account. In that account, Lordship will find that overdue amount which was given in the paper publication was paid on 1/3/2008 after cancellation of the refacement letter, Lordship.
They had given me 15 days time to pay. I have paid in terms of that advertisement only. Kindly see the dates.
Yes. And till today, as per my instruction, as on 31/12/2018, the outstanding is 59,83,000 dollars.
No, that is 2018. We are in 22 now.
My lord, certainly it has come, but so far as my instruction is 59,83,000 as on 31/12/2018.
Yeah.
And Lordship, another thing, there is an order of this honorable court which was given in Annexure 5.
Now they're not now they're not respecting the refacement. That's all.
Annexure 5 to Lordship, kindly see page operating part at page 30.
Yes.
What is the order of this honorable court? I am permitted to place. The petitioner is also not ready to apply for one-time settlement. It has alleged that there is no outstanding dues with the petitioner has to pay, and the payment which have been made by the petitioner have not been regularized. Thereafter, this honorable court directed, considering the appropriate facts and circumstances of the case, we dispose of the writ petition with a direction that the writ, without prejudice to the right of the claim of the parties, it will open for the petitioner to make an application for one-time settlement. However, the opposite party shall furnish the statement of account to the petitioner. So the actual amount which is at present outstanding against the petitioner in respect of the loan in question. In case the petitioner produce the proof of any payment made by it, same shall be taken into consideration. Before furnishing the statement of account, the petitioner and thereafter the application for one-time settlement is made. If made by the petitioner, shall be considered and disposed of within a period of 1 month from the date of receipt of the such application. No coercive action shall be taken. And the last line, in case the petitioner does not make any application for one-time settlement, this order will not be operated. This order was passed in the 9/7/2009. There are no application, even though he has not made an application. We have taken under OTS application and we have very much communicated to them. That he has not complied with.
In case I don't want OTS, I have paid the entire liability. Why should I apply? 1 second.
This is a disputed question of fact. My lord, petitioner is saying there is no
Kindly
due.
see the refacement
And
order.
as per my statement, the 59 lakh somehow is useless.
Kindly see the refacement order, my lord. The period is available up to 2013, and much prior to that, I have paid the entire amount. Much prior to that. And before that, they are cancelling. That's the point. Kindly see, my lord. Before that period comes, 2022-2013, they are cancelling the refacement. They are not at all speaking about this refacement. That's the peculiarity. They must come out to your lordship about this refacement.
All right. Order is reserved. Right.
Same order in 3 cases, another same letter
One
order challenging.
One order will govern
One,
all
yes.
the matters.
Weekly list item number 38.
matter of regulation of service, my lord. Petitioner matter of regulation of service, my lord. The petitioner unarmed skilled labor working in the erstwhile central electricity supply utility for last 7 years. Now also he is continuing there. They have not filed counter in this state.
Now the management has been taken over by Tata Power. New management has come. Let him approach.
Counsel for the opposite party informs the court that the Tata Power North Supply.
Tata Power Central Orissa Distribution Limited.
Central Orissa Distribution Limited has taken over the opposite parties. It will be open to the petitioner to make a fresh representation to it in accordance with law. The petition is disposed of.
List item number 39.
Representation, madam.
Yeah.
List item 39.
I am here as this writ petition seeks your lordship's kind intervention against acquisition of land under provisions of Principal Land Acquisition Act 1894 for a company at the behest of Infrastructure Development Corporation, that IDCO, bypassing all the provisions prescribed under the statute for a company, for acquisition of land for a company. Under Part 7 of the Land Acquisition Act, acquisition of under the heading acquisition of land for companies, specific provisions are made from section 38A to section 50. And here, my lords may kindly appreciate for a moment. My lords may kindly appreciate for a moment. The acquisition was made. The company that is opposite number 5, one carbon. So, I'm sorry, am I audible, madam? Am I audible, madam?
Yes.
Well, the opposite number 5 company applied under the law, it has to make an application under Rule 4 of the 1963 Land Acquisition Rules for seeking permission from the government for making proceedings for acquisition of land, of private land for allotment to the company, and there the company has to also specify for what reason the private land is being sought to be acquired, whether it is for construction of the structures for benefit of the employees appointed by the company or for development of the company's buildings. And in the instant case, my lords will kindly find neither such applications and in the count affidavit they have filed throughout, not a word has been spoken on this question as to whether they have applied to the state government under Rule 4 of 1963 Rule of Land Acquisition Act, and whether, and after the application is made, may kindly appreciate for the mandated provision under Rule 4 of 1963 Land Acquisition Rule is, once the application is made by a company provided under the provisions from section 38A to section 41, the government will appoint a committee to see whether the company seeking allotment of private land or even government land for its company activities is reasonable, and such acquisition shall not hurt the private individuals nor cause any inconvenience to the government, nor the company making such acquisition will make any windfall gain. And that provisions having not been followed, the entire acquisition process, my lords may kindly find, is a nullity, and therefore there was an order passed by this honorable court on 9/3/2011 staying the further proceedings. And before that, my lords may kindly have a look. The petitioners made a representation to the land acquisition collector under Annexure 4 series. Under Annexure 4 series, they represented to the opposite party, the collector, that such acquisition will not only hamper the locality, the local village, but it will cause immense pollution, the immense loss to the human life, and the local people will suffer from various kinds of dreaded diseases like tuberculosis, asthma, and all those things. Therefore, the acquisition of private land now located here, all are residential lands, all are the land belonging to local village, and therefore the acquisition may not be proceeded with. They also filed an objection, my lord, to kind of look under section, under preventing section 5A notification. And under section 5A notification, after the objection was filed with the collector issued a notice to the beneficiaries and the complainants, and the complainants also attended the 5A section notification hearing, but thereafter the collector, without informing the complainants the result of the 5A notification, passed an order under Annex 5 on 27/3/2009, directing the collector, requesting the RTC to pass notifications under section 6, that is the declaration. My lord, should kindly find the law is crystal clear. For a moment, if I have permitted, I may place section 40, that no declaration under section 6 of the Land Acquisition Act could be issued by the authorities unless the government is satisfied on the provisions contained under section 38A to section 31, and whether the company has made at all an application under Rule 4 of Rule 4 of 1963 Land Acquisition Rule. Without that, the government cannot proceed for acquisition of a private land or government land even for a company. Else, may I place for a moment section 39?
Yes.
Yes, sir. Now, section 39. It provides, my lords, previous consent of appropriate government and execution of an agreement necessary. But an agreement has to be executed with the government by the company in order to, by giving undertaking that the land, that is by way of an affidavit. That's of God. That's 1894 Principal Act.
Yes.
Well, section 39. Previous consent of appropriate government and execution of agreement necessary. The provisions of section 6 to 16, both inclusive, and section 18 to 37, both inclusive, shall not be put in force in order to acquire land for any company under this part, unless with the previous consent of the appropriate government, nor unless the company shall have executed the agreement thereafter mentioned. But here the approved body is the Industry Department. It's the Industry Department to which the company was duty bound under law to make an initial application under Rule 4. When I am placing for a moment Rule 4. Rule 4 of 1963 rules. I am placing for a moment. As Rule 4 says, it's crystal clear. Land Acquisition Companies Rule 1963. May I place it, madam?
Yes, please.
Yes, madam. But the Rule 4 says Land Acquisition Committee for the purpose of advising the appropriate government in relation to, I'm sorry, madam, for a moment. In relation to acquisition of land under Part 7 of the Act, the appropriate government shall, by notification in the official gazette, constitute a committee to be called the Land Acquisition Committee. And there they have said that the committee shall consists of such and such the secretary to the government of the Department of Revenue, Agriculture and Industries, or such other officers of each of the said department as the appropriate government may appoint, and such other members as so and so. Then rule 4, this is rule 3. So rule 4 says appropriate government to be satisfied with regard to certain matters before initiating acquisition proceeding. Whenever a company makes an application to the appropriate government for acquisition of any land, that government shall direct the collector to submit a report to it on the following matters, namely, that the company has made its best endeavor to find out land in the locality suitable for the purpose of the acquisition, that the company has made all reasonable efforts to get such lands by negotiation with the persons. So all these conditions are met there. So first of all, there is no application. I did not bother your lordship with placing these rules. The very first.
Let us hear the state council, sir.
Yes. And I'm opening the opinion 1, 2, and 3. IDCO is being represented by my lord, Mr. Patnaik. But so far as the stand of the state is concerned, my lord, this land acquisition proceeding is not coming under Part 7 of the Land Acquisition Act, my lord. Rather, it is coming under Part 2 of the Part 2 of the Act, my lord. I would request my lord to come to Section 4 of the Land Acquisition Act, my lord. Section 4 says, my lord, I'm just reading out the first 2 lines, my lord. Publication of preliminary notification and powers of officers thereupon. Whenever it appears to the appropriate government that land in any locality is needed or is likely to be needed for any public purpose or for a company, a notification to that effect shall be published in the official gazette. Now, Section 4.1 notification was issued pursuant to this Section 4, pursuant to this.
5A objections.
And he didn't file any objection. Nobody
he did not file. All right.
Yes, my lord. So the issue that is the procedure to be followed if the land acquisition is acquired under Chapter 7 is not required when the land is acquired under Section 4.1 or under Chapter 2 of the Land Acquisition Act. So therefore, the formalities which are required to be followed under Chapter 7 is not required for Chapter 2 for the land acquired under Chapter 2, my lord.
All right.
And secondly, my lord, land acquisition 4.1 notification was issued, Lord, on 4/10/2008, and the writ petition was filed on 6/12/2010. So there was a delay of 2 years. And thirdly, we have also said that the Rule 4 of Land Acquisition Companies Rules 1963, what my learned senior just now stated, my lord, that is not applicable when the land is acquired under Part 2 of the.
All right. Yes, Mr. Patnaik.
My lord, I am appearing for the IDCO, my lord. This is not only for the company. We have applied for the entire 8.41 acres, my lord. We have applied for the industrial development under Section 31 and 15. And secondly, my lord, what is the locus of the petitioner? He has not mentioned in the writ petition. It only says that is the villager, my lord. And thirdly, my lord, it is also at belated stage, and after 6.1 notification was made on 11/5/2009, he has come before this court, my lord.
Why did we stay this land acquisition case in our interim order? Why did we stay that? Any idea?
My lord, I had appeared after the issuance of notice, my lord.
Because of further proceedings in LAC number 4 of 2008 pending before the SLAO Jagat Singhpur was stayed.
Yes, my lord.
I wonder why. That is for disbursal of compensation.
My lord, we have already deposited the amount also.
I don't know who it helped. For 10 years now that stay has continued. All right.
Yes,
Mr. Gajendra.
Yes, may I submit, madam? Madam, now
yes, sir.
May I please your my lords, I am appearing for the company opposite party number 5, my lords.
Right.
Here, my lords, as per I applied for the land, my lords. Thereafter, IDCO directed me to submit certain documents, my lord. Those documents are submitted, my lord. Thereafter, IDCO issued a letter, my lord, by an annexure. That is page 40, my lords, of J by 5, annexure J by 5, page 40 of my reply, my lords.
Right.
ITCO asked me to deposit the entire amount of 2 crore 73 lakhs 84,000, my lords.
Right.
So that was deposited, my lords, as per the annexure 10 by 5, my lords. Page 44, my lords.
Right.
My lord, data has been deposited
With this just a minute, let me complete. So, my lords, according to their, I have deposited entire amount, but now, my lords, after granting the stay order, managed to get a stay order. In the meantime, the entire property has been sold and ROR have already been prepared in others' name, my lords.
Sorry, you've already been?
The ROR already been prepared with other person's name, my lords. The land acquisition, the land which was under the acquisition, my lords, by virtue of this stay order, my lords, they have already sold the property to private persons, my lords.
Oh, I see.
That is my information, my lords. So now, my lords, I am not in a position. Now I'm not in a position to take this land, my lords. But fact remains, I have deposited the entire amount with the ITCO, my lords. So my humble submission before lordship that the amount may be refunded back to me, my lords.
Nice, very convenient, sir. Somebody will file writ petition, relief will be granted to you. Very convenient, very convenient.
My lord, I have already deposited.
Ultimately, my lord, I am the sufferer, my lords. Because
I know, but you will not come forward. Somebody will come forward. In his petition, will reject his reliefs and grant you reliefs.
Yeah, just one second, my lords. Once I have deposited the money, it's a duty of the ITCO.
So you have not bothered to come forward with the petition asking for anything back. Why should we entertain in his petition your reliefs? I don't understand this. It's not even like a plaint in a suit where you have a counterclaim. Not even that. Yes.
My lord, page number 13, ITCO has deposited this amount before the special land acquisition officer, my lord.
Right.
And 14/5/2010, my lord. We have already deposited.
All right. Yes. Yes, sir, Mr. Gajendra.
I have part to submit, my lord. I have only one point now. If your honest state council submissions is that the acquisition proceeding is not to be initiated under Part 7 of the Land Acquisition Act, which is specifically provided by kindly appreciate for a moment, acquisition of land for a company. Madam, kindly appreciate, admittedly, now the land is being whether private or government or in the locality or of the villagers being acquired for the company. And if it is a company, how can now it be said that the land is the Part 7 of the specific provision provided for acquisition of land for a company is not applicable, and it is the general principle of law provided under Section 4 to Section 4 will apply, obviously, my lord, because once these provisions under from Section 38A to Section 41 is complied with by the land acquisition collector, and the company has to mandatorily make an application under Rule 4 of 1963 rule. Then other provisions will come. Well, let's kindly have a look for a moment. It has been clearly said. That provisions, previous consent, I just placed it before I'm just for your lordship refreshing something. Previous consent of appropriate government and execution of agreement necessary for acquisition of land, without which, kindly appreciate for a moment, my lord, Section 6 to 16, that is, Section 6 is a declaration, to 16 and 18 to 37 shall not be put into force. And my learned friend just now submitted that we have come after Section 6 declaration. It's not correct. Section 6 declaration, we were following, we were objecting, and continuously we went on objecting to the authorities. We were called to participate in Section 5A hearing, and Section 5A hearing was taken up only after they issued us notice. Then what happened to Section 5A notification result is not known. They immediately came across the fact that they have issued, because the collector has requested that issue Section 6 declaration. And thereafter, my lords may kindly find Section 6 declaration first was issued on 27/3/2019 and on 11/5/2019. Section 1 was published by the Revenue Department. And this being the question, the sole question now is for my Lord's kind appreciation and education whether for a company of any nature, under any circumstances, whether IDCO has acquired land for industrial development. That is a new thing, they say. I am concerned only, my lords, we are concerned only with the acquisition of land for a company. You can acquire land for industrial development in any part of the state, but how come you would overcome these provisions? Admittedly, they never say no. They have said everybody is finding counteractivity. That there is an application under Rule 4 of the 1963 rule. And if that is not there, and if my lord would hold it and advocate it that yes, for a company, it's the mercy of the state collector, state government, and even IDCO will come forward and say, no, that section part 7 is not applicable. We will go by this general provision. Well, that general provision you have to bound to go, but only after complying section 38 to 50, at least 41. And no company can come forward state to approach the collector, my lords. That is the reason why my lords can appreciate the provisions have been specifically in the Land Action Act, that no company can directly approach the collector and take over private land.
All right, sir. All right, thank you. Orders reserved.
Weekly list item number 40.
Right, please balance. The petitioner before your lordship, my lords.
So we'll just run through the list and then come back to this.
Balance.
Weekly list item 42. 41. Item number 42.
42, your lordship. In this case, your lordship, the RI office is constructing over a gochar land. This one could, while issuing notice, status quo order has been passed. The representation of the villagers at page Annex 7 at page 19, your lordship. We have represented the Tahsildar not to construct over the gochar land. There is grazing land. For that reason, we have represented it not to construct over the gochar land. And this one court status quo order has been passed.
Let's see the counter affidavit. 1 minute.
No, counter affidavit has not been filed.
It's all right. It's all right. It's all right.
42 counter has been filed, my lord.
But copy has not been served.
All right, sir.
Here we are taking a stand, my lord. Lordship, see, the allegation is regarding construction of a office cum residence of the revenue inspector on a gochar land, and they are saying the father of the petition number 1 had donated some land. It should have been constructed there instead of this land. Our contention is, my lord, there is an excess of gochar land, so the surplus land is being used for construction of this building. Already 8.14 lakhs has been sanctioned, my lord, out of which 3.35 lakhs has already been spent towards the construction in the year 2011-12.
It's just abandoned.
I'm sorry, my lord.
That construction is just abandoned now.
It has not proceeded further because of the penalty.
How much percentage of construction is over?
My lord, the extent of construction has not been written, my lord, but
Our instruction is not constructed yet, your lord.
Here I am referring to the letter dated 12/8/2013 of the Tahsildar Kendrapada, my lord. He's saying that in inviting a reference to the letter subject cited above, I am to say that for construction of RI office at Chakrarada, an allotment of rupees 8.14 lakhs has been received during 2011-12 and 12-13 in 2 phases. Out of the said allotment, rupees 3.35 lakh has been spent, and for the meantime, the work has been stopped due to court case. We have surplus gochar land in that village for which this patch has been selected.
Yeah. Considering the reply filed by the opposite party that the excess gochar land was actually being used for the construction and not the gochar land itself, the court sees no reason to interfere. The interim order is vacated. The petition is dismissed.
Weekly list for orders item 43.
None appears dismissed. No more. The office note has been produced. Since the check is invalid, no further orders need to be passed. Right.
Weekly list item 44.
Actually, there's no instruction in this matter.
44, just put that miscellaneous case, no instructions disposed of.
Weekly list item 45.
Again, miscellaneous case, none appears, dismissed.
Weekly list item 46.
Again, miscellaneous case, none appears, dismissed.
Weekly list item 47.
Same, miscellaneous case, none appears, dismissed.
Weekly list item 48.
Same thing, miscellaneous case, none appears, dismissed.
Weekly list item 49.
Same thing, all the miscellaneous cases, we say none appears, dismissed.
Weekly list item number 50.
Again, put all the miscellaneous cases,
Item
none
52,
appears, dismissed.
we are for the opposite part.
All right.
Make all the pass-over matter. Weekly list passed over matter item number 7.
Who's in this matter, sir?
Weekly list item number 7.
Who's for the state? Mr. Katkia?
Yes.
Where is Mr. Katkia?
My lord.
How? What is the report that you have got through the SHO?
That person is in his village Surosai.
Sorry, he's in his available. Okay.
Yes, he's available.
None appears for the appellant. The appellant is stated to be available in this village. Notice be issued through the SHO to ensure the presence of the appellant before the court on the next day to explain why his bail should not be cancelled. Meanwhile, one set of the papers be handed over to the Secretary, High Court Legal Services Committee for being entrusted to a panel counsel of not less than 10 years experience to appear for the appellant. The panel counsel will get in touch with the appellant well in advance of the next date for instructions. Just on 9th May. Sorry, 12th May.
Weekly list item 27. Item number 27.
None appears as is a normal section. Sorry? All right. Counsel is present at the first call, but not at the second. All right.
Weekly list item number 40.
May it please, man.
Yes, please.
The petitioner before your lordship, my lords, is a poor blind person who operates a small open air stall of selling ghee in, my lords, these earthen lamps made of ghee. My lords, earthen lamps. My lords, he had come
Who's
to
for the opposite side, sir?
My lords,
who is appearing for the opposite side?
I'm sorry, my lords, I couldn't hear. No, this
Temple administration
Temple
advocate, Mr. Satpathy, he was sitting here.
Please read the order of 1st December 2015, sir.
1st December 2015, I don't have it.
Do you have a copy of the order dated 1st December 2015?
I have a copy of the order dated 5th February 2015 in the other case. WPC 11555 of 2008, which has been annexed to the counter affidavit.
Just show him the order dated. 1st December 2015. I'm not sure this shop still continuing.
No, it's still continuing. my lord.
All right.
It's still
Who's for the
continuing.
temple?
And in the meantime, they finished construction of the rest rooms for the pandas.
All right. You just say for the over 10 years now, there has been interim order
I have given you the
asking status quo to be maintained in respect of the petitioner's deep shop. On 15th February 2000, on 1st December 2015, an order was passed noting that the temple administration had decided to construct a restroom for the Paliya Puja Panda Sevak near the petitioner's present location. And time was granted the temple administration for further instructions on where the present petitioner could be relocated. Petitioner's shop could be relocated. Today, Mr. Palit informs the court that the construction of the restroom has been complete and the petitioner is continuing in the same location. Paragraph. It therefore appears now
I'm sorry, my lord.
that pursuant to the interim order passed by this court way back on 23rd December 2010, that is more than 11 years ago, status quo in regard to the petitioner's shop is continued. Paragraph. Consequently, an order is passed that in the event the temple administration wishes to relocate the petitioner, it will give him at least 15 days advance notice, informing him of the alternate site. And if the petitioner is aggrieved by such alternate site, it will enable the petitioner to seek appropriate remedies in accordance with law. The petition is disposed of.
My lord, I'm sorry, my lord, my name may be recorded. I was.
All right, just put on.
Obliged. Deeply obliged.
Supplementary. Supplementary list, fresh admission, item number 1.
In that manner, status quo may continue till.
Obviously, that's what I said. They'll give you advance notice.
Mal.
Let's say letter PL, my lord. Item number 1, it's a letter PL filed in the year 2014, my lord. Allegation of misappropriation of PDS items, my lord.
All right.
I have no since
All right. This is a letter received in 2014 regarding misappropriation of the PDS. There's no intimation to the court on what has transpired in the meanwhile. Consequently, the court is not in a position to pass any orders. Disposed of.
Supplementary list, item number 2.
2 is also not a PL.
Man, no instruction, man.
No instruction. Disposed of.
Supplementary list, item number 3.
None appears to
challenging the appointment of 2015.
Supplementary list, item number 4.
None appears to
Supplementary list, item number.
I am also there also. I'm virtual mode also. Item number 4, you know, see. Sorry, I have item number 5, you know, see.
Supplementary list, item number 5.
May I please, you know, see. Here only the public interest litigation lordship, the page of land in lordship having Kisama forest lordship. That has been taken away by the private opposition party in doing mischief lordship. Accordingly, we represented before the authority lordship, and the authority lordship directed on Tahsildar lordship. Lordship a glance. Annex of 13 lordship, page 51 lordship. Before that, annex of 12 also, direction has been given a lordship to the collector. Collector given direction to the Tahsildar lordship to indicate the matter and do needful lordship. The Tahsildar is sitting tight over the matter lordship since 2011, nothing doing a lordship.
What has happened in the last 5 years?
The land is as it is a lordship. That has been now enjoying by the private opposite party lordship.
No. What has happened in the last 5 years, sir?
It's true, your lordship.
You filed this petition in 2016. What has happened since then? We'll permit you to make a fresh representation, sir. You say if the cause of action survives, it will be open to the petitioners to make a fresh representation to the authorities in accordance with law, and after following up on such representation, to file an appropriate petition.
Supplementary list item number 6.
The petition is disposed of.
Item number 6.
Same lawyer. This is your matter, sir. Item 6.
I am in item 6, your lordship.
What is item 6?
The grievance is that, your lordship, the opposite party, your lordship, constructing a shelter, flood shelter house inside the school premises, your lordship. Thereby, your lordship, the public made agitation and represented before the authority. Authority, your lordship, directed, your lordship.
Again, same thing, sir.
2 page 17, your lordship, a glance. Authority has been directed, your lordship, to cause inquiry and take appropriate steps, your lordship.
Anyway, you say in the last 6 years, no effective orders have been passed in this petition.
2017, your lordship, notice.
Yeah, leaving it open to the petitioners to make a fresh representation in case any cause of action survives. The petition is disposed of. All right.
Supplementary list item number 7.
Hello. The question framed.
Not framed, sir. Question urged.
Yes, ma'am. That at page 7, paragraph 16(1), whether in the fact and circumstance of case, the law, the landed right
I
is
thought identical matter some other day we'll deal with this. Deleting 2.5 crores addition made by the AO for violating provisions of 40 AIA. Concurrent findings, sir. The present petition is directed against the order dated 2nd November 2017, passed by the Income Tax Appellate Tribunal, bracket IT80, Cuttack Bench, Cuttack, and ITA number 347/CTK 2016. By the impugned order, the IT80 dismissed the revenues aforementioned appeal, thereby upholding the order dated 29 June 2016, passed by the Commission of Income Tax Appeals, CITA. For the assessment year 2007-08, paragraph. Questions ought to be urged by the revenues regarding the deletion of the addition made by the assessing officer, bracket AO, in the sum of rupees 250,31,691 for alleged violation by the assessee of the provisions of section 40, bracket A, bracket IA of the Income Tax Act 1961, bracket Act. Paragraph. The court finds that both the IT80, the CITA as well as the IT80 have concurrently held that the amendment to the above section 40 AIA with effect from 1st April 2010 does not have was intended to have retrospective effect. It is also held and relied on the decisions of the High Court of Karnataka. CIT versus Sri Santosh Kumar Shetty, 2014, 1989 CCH 199. And in ITA 551 of 2015, bracket CIT versus Sri Scorpio Engineering Private Limited. Having heard learned counsel for the department, the court is not persuaded that any legal error has been committed by the CITA and the ITAT warranty interference. No substantial question of law arises. The appeal is dismissed.
Supplementary list item number 8.
Item number 8, running page 10. The revenue formulated the question number V is important. Whether on the fact and circumstance case, the ITAT is justified deleting additional rupees amount so and so made by the AO towards accrued interest on NPA when the assessee being a non-scheduled bank and not in accordance with 43D of the Act. Now, this is relating to the assessment year 12 and 13. The scheduled bank included in 43B in the with effect from 1/4/2017. There before that the cooperative is not included in the 43.
No, there's a decision in ASCA
decision of the tribunal coordination bench. They have been allowed, but here there is no such decision of the honorable court.
No, but what did you do? Did you challenge the decision of that ASCA cooperative bank?
ASCA cooperative bank.
Because it's for the same assessment year 12-13.
Yes, but that I could not find that order, though I searched not able to find that.
No, why should we adjourn for that? You say,
well, this is a only question is whether
coordinate bench, and if that has not been challenged, that's the end of the matter.
But I have to check. We have not checked.
Later you check, and if you find it, you can file a review.
Not guessing on that.
This is an appeal by the department against an order dated 1st February 2018, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket ITAT, in ITA number 03/CTK/2017 for assessment year, bracket AY 2012-13. The question sought to be urged by the revenue is whether the ITAT was justified in deleting an addition of rupees 374,04464 made by the assessing officer, bracket AO, towards accrued interest on non-performing assets when the assessee is a non-scheduled bank and which is not in accordance with section 43 capital D of the Income Tax Act 1961, bracket Act. Paragraph and a perusal of the order of the impugn order of the ITAT reveals that it was merely following its own order in the case of ASCA Cooperative Central Bank Limited versus ACIT, bracket ITA number 11/CTK/2017, bracket, for the same assessment year, for the same AY 2012-13, by order dated 18 January 2018 on an identical issue, paragraph. With that being the case, and with the departmental counsel not being able to point out whether the department has challenged the said order, the court sees no reason why it should interfere with the impugn order of the ITAT. No substantial question of law arises. The appeal is dismissed.
Supplementary list item number 9.
That may I please, Lord? That I may be permitted to place this matter, that being relegated by the Honorable Supreme Court, that the petitioner has again approached your Lordship by way of this review petition to challenging the illegal auction sale notice and the process of sale of the property, which is totally contrary to the rule, and the it was not properly valued, and it is contrary to the rule 6, sub-rule 7A, and the rule 9.
Let's read the Supreme Court order, sir. Page 32.
Lord, I am there. At page 32. It is an admitted position that the petitioner did not make the deposit under the one-time settlement scheme within the time stipulated therein. Therefore, it is rightly held that the petitioner shall not be entitled to the benefit under the OTS scheme. And then Sri Siddhartha Dhabe's senior advocate, the first SLP was dismissed. Then Sri Siddhartha Dhabe, and senior advocate appearing on behalf of the petitioner, has vehemently submitted that number of grounds were raised before the High Court on the legality and validity of the auction sale. However, none of them has been dealt with and considered by the High Court. The High Court has non-suited the petitioner mainly on the ground that the petitioner is a defaulting borrower, and even the payment under the OTS scheme were not made by the petitioner, it is submitted that the aforesaid has nothing to do with the legality and validity of the auction sale.
So which is this present review petition is against which writ petition, sir?
Against the review against the writ petition WPC number 3360 of 2022.
All right. So in WPC, this review petition, you say this review petition has been filed pursuant to an order passed by the Supreme Court of India on 21st February 2022 in writ petition in SLP Civil 2528 of 2022. The relevant portion of the order of the Supreme Court concerning the above SLP reads as under, take from the whole of page 33. In that view of the matter, the order passed by this court on 2nd February 2022 is recalled to the above limited extent as permitted by the Supreme Court. And writ petition civil 3360 of 2022 is restored to the file. In 3360 of 2022, you say list before the roster bench on 16th May 2020. Right.
Pursuant to my direction, I am
All right. You say 18th April 2020.
Pursuant to my direction, I am appealing today, my lord. I file my counter, my lord. But my lord, because there are several allegations in the review petition against the
review petition, we just you file it in the writ petition, sir, now.
That only we have raised the question of law, nothing else. The auction notice was issued without mentioning the description of the land.
Anyway, there's no interim order, nothing. So let it come in the normal course.
The interim order may be permitted.
The lordship fix up a date.
18th April, sir, before the roster bench.
Let the status quo of the property be maintained.
No question, sir. We're not passing anything.
Sale already confirmed.
All right.
Sale deed has been executed.
Yes, yes. Let it be, sir. Let it be.
Supplementary list item number 10.
Please, your lordship. My lord, the original writ application has been dismissed and deferred. That's why restoration petition has been filed. And due to unavoidable circumstances, I could not be present on that.
You argue the main matter now, sir.
Yes, ma'am. My lord, the Uttar Parsha Matha, a spiritual issue in Puri, and he was having some land in the district of Baleshwar, and under the Tahsil Soro. My lord, kindly see, on 13/2/1969, the ROR was published in favor of the Matha. That is annexure 3. I have annexed here it. But that is on 13/2/1969. My lord, after a period
for all these RORs and all, why are you filing writ petitions? There are other statutory
provisions. That's why I'm coming. That's why, my lord, that the ROR was published 33/1969, and unfortunately, in SRF number 91/2006, 27/1/2007, that is after a period of 38 years. This Tahsildar Soro changed the Mahfadarship of the Matha.
But the Tahsildar's order is all appealable.
Yes, madam. That is also correct, madam. I do admit, madam.
So you withdraw this and go and appeal, sir.
Yes, madam. I applied for the certificate copy. While the annexure 5 is my receipt, but till yet they have not granted. They are not granting the certificate copy. The Tahsildar is not granting the certificate copy. That is my allegation before my lord, my lord. Because my lord, annexure 5 is the receipt.
Where have you averred this annexure 5?
Annexure 5, that is the application form, the application.
1 minute, sir.
Receipt.
Para 3. So what's the reply to para 3? 1 minute. What is the reply to para 3? Look at this, para 15, Mr. Mohanty.
Yes, ma'am.
It is submitted that certified copy could not be prepared if you want a folio and court fees. What is the court fee as to deposit? What is the court fee? Why don't you indicate what is the court fee? He'll deposit it and get it.
Your lordship may directly Tahsildar, he will.
All right. One of the grievances made in the present petition. You say for reasons stated that CMA appeal is allowed. Writ petition 798 of 2010 is restored to file. In the main writ petition, you say one of the grievances raised in the present petition is that despite applying for a copy of the ROR way back on 2010-2009, it is still a copy has not still been supplied. Certified copy has still not been supplied to the petitioner, thus disabling the petitioner from challenging the order of the Tahsildar by way of an appeal. In reply to the petition, in para 15 of the reply to the petition, in para 15 of the reply filed by the opposite parties, it is stated that the certified copy could not be prepared for want of court fees. Paragraph. The petitioner will deposit a sum of rupees 250 towards court fee with the opposite party number 5.
Tahsildar Puri.
Tahsildar, my lord, the Tahsildar number
6. Opposite party number 6, Tahsildar Soro, on or before 4th April 2022. In which event the Tahsildar will supply to the petitioner on or before 11th April 2022 a certified copy of the ROR. Thereafter, it will be open to the petitioner.
May I interpret, my lord? No, the order of the Tahsildar had a SRO number, SRF number, case number 19 by 2006, in which he has passed the order.
No, certified copy of the order.
SRF number.
Yeah, 27 January 2007 in SRF case number 19 of 2006. In which event the petition it will be open to the petitioner thereafter. Challenge the said order of the Tahsildar in accordance with law by filing an appeal not later than 2nd May 2022, accompanied by an application for condonation of delay, citing the reason on account of for the delay on account of pendency of the present petition. The court clarifies it is not expressed any view on merits.
The petitioner will produce this order. Petitioner will produce this order before the
a certified copy of the order
for
we
compliance.
produced before opposite party number 6 within 1 week from today for appropriate compliance.
Supplementary list item number 11.
Next, please, your lordship. In this case, my lord, last occasion, my lord has directed the counsel for the Tata Power to take instruction, my lord. In this case, the present petitioners are the.
Let us ask him. Yes.
My lord, on behalf of Mr. D.K. Mohanty, may I please your lordship. Lordship directed to take instruction whether there is any power cut as per the allegation made in the writ petition. My specific instruction is under annexure 1, there is a direction that whenever there is a movement of elephant and that area, power supply has to be disconnected, and after getting clearance from the forest department, that has to be restored. And we are also, and that has been followed. The allegation is 6 p.m. to 6 a.m. there is a power cut on the guise of that is not correct. My government. I will also file the detailed counter, Milord, if also permit.
All right, counsel, the respondent undertakes to file an affidavit as to the exact hours of power cut in the area. The affidavit will be filed not later than 4th April 2022 with an advance copy to counsel the petitioner. List on 6th April.
Supplementary list item number 12.
Only a three ballot in this case. And now the summer season is going on. And entire 26 villages in the dark. 6 p.m. to 6 a.m. morning. Now my friend is saying that we are not disconnecting the power supply. Every day,
government is also party because government's guideline we are following. The government has instruction.
They are not following, madam.
That is my friend.
I'll take instruction from the collector whether the allegation is correct.
Meanwhile, Mr. Das, appearing for the government, states that he'll seek instructions of the collector on the allegation of the petitioner that there is that the power cuts continue for an inordinately long period. Between which hours, Mr.
6 p.m. to 6 a.m. morning.
From
6 p.m. to next day 6 p.m.
From 6 p.m. to 6 a.m. All right. List on 6th April. Right.
Supplementary list item number 12.
Lords, I beg to appear in this. These are a batch of writ petitions challenging the 148 notices. Barring the merits of the matter, which I'll dwell upon later, my lords. First of all, my lords, the officer in the order disposing of objections, my lords, contrary to the settled position, says, I will not even furnish the sanction. And my lords are aware that under 151, the sanction is an important facet. For the first 3 years, my lords, the sanction should be from the commissioner. For the last 2 years, the sanction must be from the joint commissioner or the additional commissioner. Now, in either of the cases, they have actually refused to furnish the sanction. If my lords would kindly see the order disposing of objections, annexure 9 in the first writ petition, at page 164, my lords.
Yes.
Relevant at 165, bottom, my lords, para 3.3.
Yes.
It says, it records my submission that sanction under 151 not communicated, ground of objection is reproduced. It is submitted, initiation under 147 is invalid since sanction obtained under so-and-so has not been communicated despite assessee specifically requesting for the same. My lords, the AO's comments, the necessary sanction under 151 is duly obtained from the competent.
So what is this, Mr. Chimanka?
Yes.
Where's the sanction letter? You produced the sanction letter before us.
Okay.
One of the grounds raised in the present petitions is that the department is even refusing to produce the letter by which the reopening of assessment has been sanctioned in each of these cases. Full stop. Mr. Chimanka is directed to produce before the court on the next date copies of the sanction letters issued in these cases. Advance copies thereof be supplied to Mr. Jolly, learned counsel for the petition. List on 7th April.
Lord.
7th April.
In the interregnum, the proceedings may be
okay. In the interregnum, no further steps be taken pursuant to the impugn notices. All right.
And may I request my learned friend on the other side to communicate to the officer, because he was threatening to pass the order today. He may communicate.
This order be communicated today itself by Mr. Chimanka to the officer concerned.
Right. I'm so very grateful, Malas. I'm so.
All right. All right.
Supplementary list item number 13.
May I please your lordship? Let's cover matter. Cover matter section 148 notice approval from additional commission of income tax. Paragraph 6 of the running page 16. Paragraph 6 is covered.
All right. Same order.
Only paragraph 6. Others is not relevant to this case. Only paragraph 6 is covered.
Paragraph 6.
Paragraph 6 of the order your lordship will let pass. Running page 16.
All right.
That is JCT's case is additional system.
Correct.
That has to be changed.
Yeah. You just say, considering that the sanction has been granted by the JCIT, in view of the reasons mentioned in the order dated 24 January 2022 by this court, in writ petition civil 20919 of 2021, bracket Messrs. Ambika Iron and Steel Private Limited, Assistant Principal Commissioner of Income Tax, the impugn notice is quashed. Petitions allowed no orders is quashed.
In this case, additional CCT range 1 is there.
Yeah.
Your lordship.
Okay. Additional CC.
Yes.
Yeah.
Supplementary list item number 14.
None appears discussed.
Supplementary list item 15.
15. No, the demand is more than 1 crore 46 lakhs 14,890, and question has been framed at page number 10. Whether on the fact and circumstance of the case, the Honorable ITT failed to apply one of its ingredients of section 37(1), which is important, of the Income Tax Act, that the expenditure must have been incurred wholly and exclusively for the purpose of business or profession while adjudicating the SSC claim of alleged.
Sir, again, concurrent findings have not interfered. The present appeal is directed against the order dated 31st August 2017, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT, in ITA number 236 of CTK of 2015 for the assessment year bracket AY 2010-11. By the impugned order, the ITAT dismissed the revenues appeal for the aforementioned AY, thus upholding the order dated 10th February 2015, passed by the Commissioner of Income Tax Appeals, bracket CITA. Paragraph, the questions ought to be urged by the revenues whether the CIT-A and the IT-80 failed to apply one of the ingredients in section 37 bracket 1 of Income Tax Act 1961 bracket Act while adjudicating the SSC's claim of commission payment. It is thought to be contended that the CIT-A and the IT-80 did not examine whether the above expenditure was incurred wholly and exclusively for the purposes of business and profession. Paragraph, having examined the orders of the CIT-A, concurrent orders of the CIT-A and the IT-80, the court finds that the conclusion turned purely on facts, giving rise to no substantial question of law. Consequently, the court declines to frame the question as urged. The appeal is dismissed.
Supplementary list item number 16.
My lord, the same matter has been fixed on 19th April. All matters, identical matters. 19th April.
All right, list on 19th April.
Supplementary list item number 17.
In all the cases, I have given the number.
Supplementary item 17.
None appears for the appellant, dismissed on opposition.
Supplementary list item number 18.
I am appearing for the opposition.
All right, sir.
Supplementary list item number 18.
May I please, my lord?
Who are the encroachers, sir?
My lord, opposite party number 52. My lord, I have met the parties, my lord.
All right. The petitioner's representation, bracket annexure 3. What is there that you've delivered this representation, sir?
Before the collector, my lord.
What is the proof of delivery?
Item 18 defects are there, but copy has not been served.
No, where is the proof of delivery?
Yes, my lord, date will be fixed, but the
Proof of delivery of this representation.
My lord, the date is.
Sir, proof of delivery, sir.
12/1/41. My lord,
Proof of delivery of this representation.
My lord, that is also Xerox copy is there, my lord.
What?
Collector, my lord. They sought the copy.
Is there a stamp of the collector, diary number?
Collector Balasore.
Is there a stamp?
Stamp is there. There is a signature also.
Is there a seal of the office of the collector, sir, on this representation? You say in the absence of any proof of delivery of the representation to the collector, it's not possible for this court to issue directions to the collector, leaving it open to the petitioners to file a fresh representation. And after following up on the same to seek appropriate remedies in accordance with law, the petition is disposed of.
Supplementary list item number 19.
I have challenged two amendments to section 16 of the Sri Jagannath Temple Act, being violative of the legislative intention behind enacting section 16.
Who are you, sir?
I'm a social worker and a devotee of Lord Jagannath.
So how is it affecting you? How are these amendments affecting you?
Well, it relates to the property of Lord Sri Jagannath. So as a common citizen, it is my duty to protect those things.
I don't understand. How does it affect? How does this notification dated 9 January substituting section 16(2), how does it affect you? What does it do?
Well, this amendment takes away the power of the government, firstly. Secondly, it allows the committee to arbitrarily exercise in disposal of the temple property. So as a devotee of Lord Jagannath, it is my duty to protect the property of Lord.
1 minute, sir. Everybody's got great duties, no difficulties.
Vis-a-vis between government and the committee. Whether committee will be empowered or the government. He is no way concerned with that.
He's just a common, he's a citizen. He says the power of the committee is getting increased. You're apprehending the committee's power is increased.
Three things I have challenged. First is that section 16 is
no, you want power to be with the committee or with the government?
With the government.
Government.
You think these amendments give too much power to the committee?
Yes, my lord.
How do you say that?
Well, kindly have a glance at page 7, section 16.
Yes.
Clause 2.
Madam, prior to the amendment, it reads as, say was otherwise expressly provided in this act, no immovable property taken possession of by the committee shall be leased out for more than 5 years or mortgaged or sold or otherwise alienated, except with the previous sanction of the state government.
Right.
Now, by the amendment, by the annexure 2, it's substituted. Say was, my lord, at page 15, annexure 2. It reads as, say was authorized provided in this act, the immovable property taken possession by the committee may be leased out, sold or otherwise alienated by it, subject to such condition and exception, and in such
Not
manner
even
as
that
may
5
be
years.
prescribed. This takes away the power of the government under section 30 and confers arbitrary power on the committee. This is my plea. This is the first challenge.
They say we'll issue notice on this. You say notice on the IA as well.
There is a interim application also.
Yeah, notice on that. Mr. Mohanty accepts notice on behalf of the opposite parties. All of them, sir?
No, sir. I read part number 1 and 2.
1 and 2? No,
sir.
even 5, 6 and 5 and 6.
5 and 6. No, 6 also commissioner, that is separate lawyer is.
Okay. 1, 2 and 5.
2 and 5. No, 3 is different. You have to take notice.
Notice be issued to the remaining opposite parties by registered speed post and additionally through the standing counsel, if any, for each of them. Returnable on the next date. The tracking report placed in record. Counter affidavits be filed within 4 weeks of service of notice. Rejoinder, if any, for the next date. Paragraph. All actions taken pursuant to the amended section 16(2) of the Sri Jagannath Temple Act 1954 would be subject to the outcome of the present petition. The counter affidavit filed by the opposite parties will specifically indicate the details of the transactions entered into pursuant to the amended section. List on 17th May.
Supplementary list item number 20. Item 20.
May I please, your lordship, my lord, last time my lord heard the matter and kindly have a glance to the last order, previous order. In the previous order, Mr. G.D. Kaur was to be informed and is now to inform before this honorable court between the disputes of the 50 years more has been settled outside the court, and the property now stands in favor of the elite petitioner number 3, that the opposite parties 3 to 7 agreed that yes, let it continue so that there will be an end to the dispute.
And I agree with this proposal, and I have got the specific instruction because very old lady that I have no objection is the appropriate order will be passed in that effect. Because my lord, here is a development, very good development. My lord will appreciate this opposite party's granddaughter has married grandson of the petitioner.
Oh.
So dispute by that way, dispute has been closed,
Right.
which I also heartily appreciate.
All right. It is stated that the granddaughter of the opposite parties.
This opposite party,
Right.
Basanta.
That means petitioner number 3's son is the grand son-in-law of the opposite party number 3.
Opposite
So
party
now
number
there is no dispute between
has
the family.
married the grandson of the petitioner. And that therefore the disputes have now been settled between the parties. In that view of the matter, no further directions are called for in the present petition. It is disposed.
So that the annexure 1, that I have come before my lord to quash the annexure 1. If that is quashed, the property now stands in favor of the
It is
petition
agreed by
number
all
3.
parties that in
will
view of the
continue.
settlement reached,
I have no objection.
Annexure 1, the order in Annexure 1, that is order dated 15 July 2003 of the Additional District Magistrate Puri in OEA Appeal number 19 of 1995 stands quashed.
Supplementary list item 21.
Virtually, it is in my lord's hands. It is a long dispute to that land is only for 5 decimal. It is a government land of petitioner number 3. And for that,
Main place, Puri land for that.
All right.
21 my lord, on behalf of Mr. Mahapatra, my lord, taken up next week any other day, my lord.
No, let's not. Who is unwell?
My throat sore, my lord. severe
All
throat.
right. Mr. Mahapatra is unwell, stated to be unwell. List on 20th April 20.
Oh, bless you.
Supplementary list item 22.
For going to verity of the case, here in this case, the petitioner were two died. I have filed the subsequent petition of filed the IA number 16710/2021.
All that is allowed, sir. Come to the main mat.
The petitioner challenged the order in annexure 3 passed by the opposite party number 2. In spite of objection filed by the petitioner raised by the petitioners that the appeal under section 9 of the Orissa State Act is not maintainable because the settlement is made under the government circular and not under the OA Act. Still then the opposite party 2, in spite of objection held that the appeal is maintainable under section 9 of the Orissa State Act and they condoned the delay and admitted the appeal for hearing. But the fact is like this. But the case land had Debatar Bahal interest, having intermediate interest, Debatar Bahal intermediate interest. It is vested in the state government in 1972. But according to 88(3) of the OA Act, Odisha State Act, the application for settlement will be filed within 6 months from date of vesting. Nobody filed, the ex-minister did not file any statutory application under section 88(3) for settlement under section 67 of the OA Act. Therefore, the land vested to the state government and it was recorded in 1983 ROR as a Babel Wast.
Is that a 38B matter? This is a 38B.
Hello? No, 38B is the OA member of Board of Revenue, but not. No, there is the circular says that member of Board of Revenue has a power to revise the order. There is no provision for appeal if it is allowed. There is a provision for appeal under the circular to the subcollector if the application is rejected. No appeal has been provided in the circular. Provided annexure 1, I have annexed the circular.
Who's for the other side? What do you say, sir?
Circular is of the year 2000. But this, my lord, the order is passed in OA case number 14 of 91. Therefore, appeal is provided. You will also make straightway come to page 28 of the brief.
Yes.
This appeal is, this is the conclusion part of the appellate authority. This appeal is filed under section 9 of the OA Act against the order of the Tahsildar made in OA case number 14 of 91. Also, section 9 of the OA Act speaks that an appeal case against any order made by any officer other than collector, the appeal if preferred lie to the collector of the district and for the purpose of collector includes ADM of the district. It is argued by the appellant to justify this court has jurisdiction to admit the case and hearing, whereas the respondent argued that appeal will lie to the sub-collector as per the circular in clause 33 in the case of rejection of claims within 30 days. As per the argument, OA case number 14 of 91 was not a case of rejection. It is a case to allow in favor of the respondent number 1 and 2. Hence, the appeal does justify before the sub-collector. Another point is that circular at page 3 and 5 clearly says that the Tahsildar is bound by law that the Bay Bandobasti is always in possession of a person whose name appears in the ROR. Here in this case, the name of DT appears in the ROR and claiming of right title interest by the appellant appears to be justified. Further, it is argued that the land may be also settled except in case of trust estate and in respect of DTs. As this is the property of the DT, appear the name of the DT on the record, there is no justification to settle the land in favor of the respondent. Here, the argument of appellant appears to be more justified. The argument advanced by respondent that this is not a case of settlement under OE Act, it is a settlement under lease principle is not acceptable. And the judgment which is shown, my lord, it is not applicable in that case. Regarding the condonation of delay, my lord, that is dealt with.
I mean, pardon me, Lord.
Under section 5.
I mean, pardon me, Lord. Madam, kindly peruse running part 23, under which provision the land was settled. The land was settled under the government circular, department circular number 657 677 of 2000. Right, annexure 1 is the circular. Wherein, my lord, kindly see, first of all, after the Bebadwasta records, 91 there was a circular, government circular. Then there are 93 there is another circular. By superseding the circular, these two circulars, the
May I submit one thing to my lord? If your lordship sees the impugned order, the appellate court has admitted the appeal and fixed the case for hearing. Whatever the objections, defense, whatever, they can take all those objections before the appellate authority and pass. It is not a final order. What I mean to submit, it's not a final order so that it can be challenged either in revision or in application. It is only admitted.
Madam, my only submission is that he has held that is maintainable. Then it is not open to us to challenge this order.
Yeah, if it is not maintainable, why should he waste his time there?
Yes, my lord. Madam, can you?
This is not an appeal under the statute, no?
Yes, my lord.
Yes.
It is the appeal under the statute 9 of the OER. Statute says, my lord, section 9 says appeal, it is appeal.
No. Appeal under, if the order is passed under that act, not under a circular.
Yes, my lord.
No, it is order is passed under in the act, my lord, but the OEA case number 14 of 91. The case is 14 of 91. The circular came into force in the year 2000.
91 is the previous circular. There are 93 another circular. Supersede two circulars. The annexure 1 2000 circular was passed.
In 91. It is.
Yes, 91 is the circular.
91 before the circular.
Where is the circular?
Annexure 1 million.
Annexure 1
million.
Is the circular issued under the OEA Act?
OEA Act, because it is circular. But can 696, section 9 can 6. The appeal provision.
Annexure 1 of the year 2000.
No, this circular has made no reference to the OEA Act.
But OEA Act is very active, but the provision says that
I'm saying something in your favor, sir.
My lord.
The circular makes no reference to the OEA Act.
No.
No.
So how can the appeal against an order passed under the circular, like, that's the question.
No matter your lordship may kindly see page 15.
Don't think it like.
Your lordship may kindly see page 15.
20.
15, 1-5. Circular, your lordship may kindly see. 23, the Romanian XX33. In case of rejection of claim of any person, a 30 days time for appeal to the sub-collector should be allowed.
That's right.
But here, my lord, the order is allowed, not rejection.
No, but anyway, it's not under the OEA Act, please. It's not under the OEA Act. That's the point he's making.
No,
this entire circular is not under the OEA Act.
Even if it is not the OEA Act, your lordship.
No, then how do you file an appeal under the OEA Act? There's the question of maintaining such an appeal at all.
No, my lord, if the order is, my lord, the lower court has allowed it, then it is appealable under section 9. If
there's no section 9, nothing here, sir. This is not a statutory function at all being exercised.
But if it is rejected, your lordship appeal is liable.
You're presuming everything is happening under the Act.
Your lordship may visualize this. In case of rejection of claim of any person, a 30 days time for appeal to the sub-collector should be allowed.
Even that appeal is not under the OEA Act. You're making the mistake there. Even that appeal is not under the OEA Act.
But fact remains that may not be, it is not a rejection. It is specifically stated herein. And another point is, your lordship, the person who claims for it, his name must be recorded in the name of found place in the name of in ROR. But his name is not found place in the ROR. So he cannot take shelter of that.
Where do you challenge it? When do you challenge it? All that matters, sir.
Madam, can you see page 16, column number 24, Roman 24, 26, sorry. The member of Board of Revenue Orissa shall have the power to revise any case instituted, rejected, dismissed, allowed, or pending with any authority subordinate to his or own motion. That is the circular.
It's subject to overall. The OEA Act is brought in there, sir. Subject to the overall provisions of the OEA Act.
Yes, sir.
So then it is issued only under that Act. Then all of this is happening only under the Act, sir. All of this is happening only under the Act.
No, my lord.
Yes, yes.
No, madam.
You just now read out this provision, 26.
26, that member of Board of has the power to revise. Not that the appellate court.
Only he will not have, only he can't be given power under the OEA Act. Either all authorities are exercising under the OEA Act.
No, my lord. The member board of the power because under section 38B, just like that power has been invested in on the
No,
circular.
no, no. It can't work
So, my
like
lord,
that.
kindly see annexure section 9 of the OE Act.
Yes.
How the appeal is amended. Appeal against the collector's order under section 5, 6, and 7. That is the
Actually,
headline.
there's another reference to OE Amendment Act in clause D, page 12. Actually, it's supposed to be under the OE Act. I was wondering, actually, the circular can't be in isolation.
May I permit to place section 9?
I think since the main appeal is pending, let it go ahead and decide the main appeal. But maintainability, we'll agree with. Yeah, no, the maintainability. So we're dismissing the writ petition.
Madam,
Let
can
the
you see-
appeal carry on, sir.
Madam, can see the answer section 9.
Right.
My lord.
Right.
How the appeal is maintainable.
Right.
Appeal against collector's order under section 5, 6, and 7.
Right.
This is not an order under section 5, 6, or 7 of the OE Act. 5, 6, and 7, 5, 6, and 7 says statutory settlement under section 88(3) if the application is made after vesting within 6 months. Then the 6 and 7 is settled under the land is settled under section 6 and 7. When an appeal against any order of the collector means OA collector. Collector under section 4 of section 3B, clause H, I, K, section 5, section 1 of section 7, 6 and 7, section 3 of section 8, and section 3 and 4, section 8A, if preferred within 60 days of such order shall lie to the Board of Revenue, which shall dispose of the appeal according to the prescribed procedure. Where the appeal is lied to the ADM.
No. So Board of Revenue, what is challenged here?
Challenge the ADM's order.
ADM. So we're not on the ADM.
Well,
This is about the Board of Revenue. This is appeals to the Board of Revenue, sir.
OA case was filed under section 6, 7, and 8 because it is of the year 91.
No, but if this is an appeal under 9, how did it lie to the collector?
It demanded.
The section 9 talks of appeal to the Board of Revenue.
If it is passed by the OA collector, it is ADM, before ADM.
Huh?
If it is passed by OA collector, your lordship, it is before ADM. That is the appeal.
Provided if such order is passed by the officer than other than a collector of the district, appeal is preferred within 60 days of such order shall lie to the said collector, who shall dispose the appeal according to same procedure or as prescribed disposal of appeals of Board of Revenue. But here in the moot question is that the order must be passed on the section 5, 6, and 7. Otherwise, the appeal is
He
not
says it is
material.
under 7. You're saying this is an order under section 7?
7.
No,
Yes.
this is not section. The manual can see answer 1, answer 2. Manual can see the settlement of how settlement is made.
That circular was not in existence in 91.
No, manual can see light one another circular is there.
Case was filed in the year 91.
Manual
Under
can see
section
answer 1.
Section 6, 7, and 8.
Manual can see answer 1. Government circular has been 91, 93 has
We'll
been
reserve
referred to.
orders. Okay, orders reserved. We'll see what.
Madam, I may permitted to file to do one decision of my lord, swearing my lord.
Yeah,
say-
all permissions granted, sir.
My lord. Madam, filing two decisions. Where is my lord have held that appeal is not material under section 9 of the OE Act. If it is made and settled on it.
Supplementary list item 23.
None appears dismissal not possession.
Supplementary list item 24.
24, no instruction, my lord.
No instructions.
Supplementary list item 25.
Infractuous.
25 infractuous.
Yeah, 25 infractions.
Supplementary list item number 26.
Today I am filing for a rejoinder matter. Counter has been filed, but no rejoinder has been filed.
What's the matter about, sir?
The matter about the petitioner prays for to construction of the lower subsoil irrigation.
All that is over, sir, long ago now.
My lower subsoil irrigation project, which is constructed in the district of Balangir,
which is the lifeline of Balangir, my lord. Because after the construction of that irrigation project, my lord, drinking water facility will be solved. Irrigation facility will be the hilly area. Thirdly, all other substantial benefits of the said areas will be benefited. The project has been started in the year 2001. Till today, no substantial progress has been by the.
What do you mean by substantial progress?
The construction work has not been speedily continued, my lord. The compensation amount has not been disbursed to the
too many things you're combining in one. Who are the people who have not got compensation? Do you have the names of people who have not got compensation?
There's so many meetings, my lord, that is annexed.
Sir, answer the question I'm asking you. Do you have the names of persons who have not received compensation?
I have not.
You do not have. Then you have simply come to with the petition saying people have not received compensation.
No, my lord. I am.
Kindly do some homework, sir. Don't simply walk into a court making broad sweeping allegations. Be specific. Otherwise, the court cannot help you. Try and be specific. Point out specifically these persons have not got compensation. Then we can ask them questions. If you make these broad sweeping allegations, they will also not be in a position to answer. You say the petition is full of broad sweeping allegations concerning the Lower Subtail irrigation project with no specific instances, thus disabling the court from issuing any effective directions. The court is therefore not in a position to entertain this PIL. The dismissal of this PIL will, however, not prevent individuals who may be aggrieved from approaching the authorities for reliefs in accordance with law. The petition is dismissed to the above observations.
Supplementary item 27.
My lord. Pardon to mention item 23, I am present, my lord.
The affidavit dated 8th August 2014 of the Additional Block Development Officer, Nandapur Block, Nandapur, has been produced. The court expects the authorities to follow up on the report of the collector in accordance with law. The petition is disposed of.
No, I may permit to mention item 33 was there, but
item 27, your lordship has disposed
of.
Let item 23 be taken up.
All right, tell us.
In this matter, initially there were two prayers. One was against the transfer of the petitioner to Bhadrak Judgeship, and second is his non-promotion. About that transfer, he does not press this, and order dated 9/12/2014, passed by this honorable court, may kindly be perused. In that order, the opposite party number 2 and 3 were called upon to produce the records of the process of promotion as well as the disciplinary proceeding for scrutiny of the court. So whether those records have come or not, I do not know. But that is necessary for perusal, since the allegation of the petitioner is that no proceeding was pending when the promotion matter was taken up.
How old is the petitioner, sir? What are your instructions, Mr. Mudri?
And I have already filed the counter affidavit.
Rejoinder, additional counter.
This has to be finally disposed of.
This has already been disposed of.
No, this has to be finally disposed of.
Or list for final hearing on 1st August.
Lord, may I try to take it up on some other day?
1st August, sir.
Several sugar level has gone down.
1st August, sir. It is adjourned to 1st August. Supplementary list item number 28. 28.
None appears. This was not possible.
Supplementary list item 29.
Taken on next week, man.
No. Tell us what is this.
PIL file for railway overbridge, my lord.
Sorry?
This PIL is filed for railway overbridge for labor crossing.
What has happened in the meanwhile?
I don't know. No, nothing has happened.
Permitting petitioners to file a fresh representation if any cause of action survives. And after following up on such representation to seek appropriate remedies in accordance with law, the petition is disposed of.
Supplementary list item 30.
None appears. Dismissed on opposition.
Supplementary list item 31.
None appears. Dismissed on opposition.
Supplementary list item 32.
But it's rendered infructuous, my lord.
Infructuous.
Supplementary list item number 33.
33, my lord. I pray for next week, my lord.
No. Tell us what the matter is about.
My lord, what has happened in this case, my lord? The file is misplaced.
All right.
This
matter, the petitioner states the file has been misplaced.
My lord,
the petition is dismissed on non-prosecution with liberty to the petitioner to revive the petition as and when he is able to locate the file. All right.
My lord, let it come next week on any day.
Any date that you file the application, will take it up.
My lord, what has happened in this case, my lord? This matter relates to PIL.
Yes.
PIL, and the prayer of the petitioner is to give direction to the opposite party to take step for removal of the crusher unity.
All right. We're not like
and prevent the industry from dumping.
We pass the order, sir. Carry on. Call
Supplementary
it.
list item 34.
None appears. Dismissed to non-prosecution.
Item 34.
Tell us what is it?
Legal function of the Gram Panchayat headquarter of Kodagaon that was fixed at Nilakanthapada under Annexure 1, Lordship. Kindly see page 12 of the Annexure 1.
We are not going to interfere in matters like this, sir.
Lordship?
Case of 2016, my lord.
Yeah. By now, the Gram Panchayat will already be held there.
Yes.
Due to passage of time, the prayers in the present petition have been rendered infructuous. Petition is disposed of. Yes.
Supplementary list item 35.
May it please, your lordship. My lord, this is a PIL filed by a number of persons, wherein our allegation is also since long pending before the collector appoint part number 2, that is under Annexure 9. That has also been directed by Secretary of Revenue under Annexure 10 to the collector Bhadrak to take up the matter. In spite of that, the collector is not doing. The fact of the case is that a public road as such recorded in the name of government under Annexure 1, page 27 has been recorded in the name of opposite party number 5. Absolutely in illegal way it has been recorded, being hands in gloves with the government servants, it has been done. After much resentment, this matter has been taken up, and finally, as per the order of Annexure 8, the legible copy I have filed, the land which has been recorded, that has been cancelled. Your lordship may kindly see Annexure 8, the land which has been recorded in the name of the opposite part number 5 in the ROR, that has been cancelled. That is Annexure 8. If your lordship will permit, I'll read Annexure 8. Only the
cancelling ROR and all you can do under statute, sir.
Yes, that has been already done. The land in the name of opposite party number 5 has already been cancelled as per Annexure 8. Now the Annexure 8, the last one, the lease 171/2000, they have ordered, as per the report of the audit para 4, the settlement of the case land be cancelled and submitted to RDC CD for confirmation. The cancellation settlement be made by the lower court Tahsildar Basudevpur. Now the thing is that in spite of everything being done, The land till today has been recorded. The ROR has not been corrected. The RI report says there are 5 commercial houses constructed there on, which is a public road. This road
Find
has
out
been.
what the correct status is. Present status.
Present status, my lord.
To find out, Mr. Das states that he'll ascertain the present status of the land in question and revert on the next date. List on 10th May.
Supplementary list item 36. Item 36.
36, my lord. Question frame at page 5. A 12A registration matter. It is Orissa Olympic Association, not charitable activities. One circular is there.
Or it will just say notice returnable.
Same in
Or it, notice returnable 2nd August.
same is 552018. Same order will kindly pass.
Supplementary list item number 37.
55 is already listed or not yet?
No, not yet listed.
Or it taken on board. 55 also notice returnable same date. All right.
Supplementary list item 37.
So item 37, I please your lordship. Let's see here, the claim of the petitioner has been torn down by the OP number 2. So collector Sundargarh. So far the recording of the water reservoir in the name of the state government in view of section 5B of the Orissa Merged Territories Village Officers Abolition Amendment Act 1976. The act.
What about replies? Have you filed your reply, Mr. Das?
No, sir. I have.
You have to file your reply.
The state government has filed the reply.
I have filed.
You filed?
Yes, madam.
There was a direction on 26th August to
You've
serve
got
a
the
copy of the
counter-affidavit?
writ petition.
The Tahsildar has filed. That is available.
Have you got a copy of the counter affidavit filed?
Yes, yes, I have received a copy.
23rd August.
You do not want to file rejoinder?
Lordship, yes, I am filed.
All right, rejoinder be filed.
Your lordship had directed the petitioner to serve a copy of the writ petition to me within 3 days. That the order is 26th August 2021, order number 4. Till today, copy has not been served on me. I am an intervener. Your lordship may read 26/8/21. Issue notice, Mr. Kunti accept notice on behalf of the intervener. Extra copy of petition be served on him within 3 working days.
All right, please serve it, sir. Rejoinder be filed before the next date.
I'll file counter affidavit to the reporter within 4 weeks.
All right, 11 July.
Supplementary list item 38.
May I please, your lordship? In fact, there is a noting that I have not filed the rejoinder. I have already filed the rejoinder. And your lordship, after hearing the state council and to the petitioner, were pleased to pass the order on 8/11/2021. And there is in paragraph 3, your lordship keep a direction to the OP number 9. What the impugned order is silent about is whether the purpose for which the land was earmarked, that is Smashan Kisam, has been changed in accordance with law before permitting the construction of the Panchayat Bhavan.
We have filed the counter affidavit. My lord, senior has filed a rejoinder, my lord. Here the impugned order is, my lord, that Tahsildar has identified a piece of land.
This fact has not been replied. The specific question raised by your lordship in paragraph 3 has not been replied in the counter affidavit. If my friend has replied, kindly show any from where it has been mentioned.
All right, Mr. Samal, kindly allow him to reply. You are not even allowing him to reply, sir.
Sorry, madam. No, I am just pointing out, madam.
Counter has been filed, my lord. Senior has filed the rejoinder to it, my lord. Here the impugned order is, my lord. The collector has passed the impugned order saying that the burial ground which was there initially, upon which the Panchayat building is being constructed, my lord, that building has already been constructed to the, it's on the fag end of construction, my lord. Already substantial amount has been spent upon it. And in lieu of that, as per the revenue department's notification, my lord, in lieu of this Samsan burial ground, my lord, the another patch of land has already been identified. That is in fact larger than the land which is being acquired now. An area of 0.59 decimal of land has been
So you will give
identified.
up this, you will not construct here then?
My lord, this construction is almost completed, my lord.
No, my lord. It has not been come. I have annexed the photograph. I have attached the photographs in my writ petition as annexure. If my rejoinder may be called for and the matter may be taken up next week, it will be made clear. they have not raised the construction and they have filed an affidavit.
The rejoinder
I
stated
have,
have been filed by
I have
Mr.
attached.
Samal, just listen. The rejoinder stated have been filed by the petitioner. We brought on record. Interim order to continue. List on 27 June.
Supplementary list item number 39.
39 or 40 may be disposed. May I pray for a shorter date, my lord? I'm sorry, my lord. 29 June, my interim order is continuing, my lord.
All right, 9th May.
Lord, 40 may be disposed of because yesterday your lordship passed similar order.
In view of the order passed in ITA 28.
28.
ITA 31 of 31 of 2018.
All right, in ITA 31 of 2018 on 14th March 2022, the present appeal is disposed of in the same terms.
And 30 minutes kindly fixing next week because one judgment I have to charge not.
All right, at the request of Mr. Sal.
It is already admitted, nobody is appear in this case.
Oh, list on 21st July.
39 is